My lords, we beg to make a consensus prayer. Item 10 of part 2. This is a make appeal, my lords. If this matter may come up after the ensuing vacation, my lords.
You appear for which party?
I appear for respondent number 7 as a legal aid counsel.
What is the difficulty?
Difficulties, my lords, we were recently appointed as to represent these respondents, my lord.
So it's a consensus prayer.
Consensus prayer, my lord.
Okay. On a joint prayer made by the learned counsels for the parties, matter stands adjourned to be listed again after the ensuing. This is Bihu vacation.
My lord.
I beg your lordship indulgence in item number 13, your lordship. This is a jail appeal, and Miss Mary is taking up the matter on behalf of the state. But as she is on leave, the matter may be adjourned as of now.
Item 13.
13, your lordship.
24:4. It is submitted at the bar that Ms. Mary L. Kyangte, learned additional PP, appears for the state respondent, and she has some personal difficulties to appear before the court today. Stop. It is also submitted that she has submitted leave of absence from 17th of March up to 24th of April 2026. Stop. In view of above, list this case after 24th of April 2026.
My lord, similar submission in item 14. This is also jail appeal and it's taken up by Miss Mary.
Same order.
Obliged.
I seek your lordship indulgence in mentioning item number 12 of the hearing list, my lord.
Yes.
If the item can be taken up on Wednesday as a fixed item.
Okay, we'll just put a note for Wednesday, no orders required.
May I please, Your Lordship?
Yes.
My Lord, I beg to mention item number 6, my Lord. This is a part third matter, my Lord. The petitioner has already concluded their arguments on last Monday, my Lord. May I pray, my Lord, short accommodation. Can it be on Thursday, my Lord, 26, my Lord? We are preparing a detailed written submission, my Lord. We will file before that, my Lord.
Thursday is a holiday here.
Let it be on Friday, my Lord, 27.
Friday is not possible, Mr. Counsel. It is the last day.
Lordship,
This
then
bench is
Wednesday.
available only up till 27th, and we have only 4 working days this week.
Lordship, let it be on Wednesday, day after tomorrow, Lordship. Day after tomorrow, my Lord, Wednesday.
Wednesday.
Lordship. It's a part matter, my Lord.
I mean, kindly keep it on Wednesday, my lord. Otherwise, my lord, it was already argued by me on last.
And are you submitting any written argument, Mr. Chetia?
Lordship, yes, my Lord. We are preparing it. We will file it on next Wednesday, Lordship.
Petitioner
But
has
I have
filed
already
it.
filed it.
Petitioner has filed it, I've seen it.
Lordship.
But,
Lordship, we will also file it.
Mr. Chetia also might want to file.
Yes, Lordship. We will file it, my Lord.
Before the date of the argument, if you can give that in advance, that would help.
Lordship. Lordship,
All
we
right.
will try
This
because
is, what is this item? Item number?
item number
6.
6.
Okay, Mr. S. Chetia, learned counsel, appearing for the respondent numbers 2 to 5, submits that he has some personal difficulties to conduct the case today, and therefore he prays for listing the matter again on 25th of March 2026. Stop. Mr. V.K. Sharaf, learned counsel for the petitioner, has no objection to the prayer. In view of above, list again on 25th of March 2026 as part heard.
Lordship. I am deeply
All right.
appreciative. My Lord.
Duly list for orders item 10.
May it please your lordship.
Yes.
Lordship, this is an anticipatory bail application. On the last occasion, CD was called for, lordship.
Do we have the CD?
No, Your Lordship, we didn't receive yet the CD.
What is this matter? Anticipatory bail.
Lordship, this anticipatory NDPS bail matter, Lordship. This matter was filed against the information report dated 5/5/2025. Lordship will find that information report in page number 14.
14.
The typed copy.
Madam, can you increase the volume of your mic out there? Is it possible?
Yes, Lordship.
You are audible, no doubt, but it's not very loud.
Lordship, is it better now?
Can you control it from here also? Who's sitting there? Raise the volume a bit. Okay, which page? Page number?
Lordship, 15.
15, 15, okay.
Yes. That is a typed copy of the information report.
So, this person named in this page 15 is the applicant.
No, Lordship. This is the tenant of the applicant. He is the landlord of the residential premises from where the alleged substances were seized.
Okay, applicant is the tenant.
Applicant is the landlord.
Sorry, landlord.
Yes, Lordship.
So this Ming Than Sang, this is the tenant.
Yes, Lordship.
So he was arrested.
He was arrested after search and seizure, and on February 3rd, bail was granted. It was a default bail, since no charge sheet was filed within 90 days time period.
Okay.
Our submission is we.
So what is the apprehension on your part? The
Lordship,
the suspect, or from whom the thing was seized, or was it seized from him?
It was not seized from him. He was not present at the premises, but he is the landlord from the residential place from where it was seized. So he's apprehending, since he is the owner of the said premises, he is apprehending arrest. He is nowhere connected in the matter. He was not present. His name is not mentioned in the information report.
All right. Anyway, let the case diary come. They don't have it today. When should we list it?
I believe they will submit it today, Your Lordship.
When should we list the matter?
Tomorrow,
can we-
it's okay. Tomorrow will be fine, yes.
We'll list it tomorrow.
Yes, Lordship.
Although case diary was called for, Ms. Vanessiami learned additional PP praised for further 1 day time to produce the same. Prayers allowed. List again tomorrow.
Obliged.
Item 11.
Yes. No one? Vanal Muan. Who's this? Vanal Muan Omi. Does the scanned copy come of the TCR? It arrived. Yes. Oh, I see. None appears for the petitioner when the matter is called. Stop. This court had requisitioned scanned copy of the TCR from the trial court. Stop. Court is informed that the same has arrived but not yet connected to the record. Stop. In view of above, list this matter again tomorrow. Ms. Vanessiami, learned additional PP, appears for the state.
Item 12.
My Lord, in this case, my Lord, the notice upon the respondent number 2 is still awaited, my Lord.
IA is filed by the state.
Yes, my Lord.
What is it about?
It's
Delay.
discharge.
Continuation delay?
Yes, my Lord. IA is delayed.
What have you filed? Criminal appeal?
Yes. Criminal petition.
Or revision petition?
Yes, my Lord. My Lord, there are 3 respondents in this case. And the respondent number 2 has fled to Myanmar. He's no longer here in Mizoram. So in order to serve notice, my Lord, we have taken the trouble to serve him through the Sampai police station. However, my lord, later we found out the proper channel that we have to serve it through the Ministry of Home Affairs. So, my lord, we are undergoing all those. So it will take some time, my lord.
You are there for 1 and 3.
Yes, my lord.
All these respondents have been discharged.
Yes, my lord.
1, 2, and 3.
1, 2, and 3.
Okay. How many days delay? 56 days. Heard Mrs. Linda L. Fumble, learned public prosecutor, who submits that by filing this application, the applicant state, state, seeks condonation of delay of 56 days in filing the connected revision petition. She, however, submits that notice is yet to be served upon the respondent number 3. And since Ministry of Home Affairs has to be routed for serving notice, she prays for how much time?
My lord, 4 weeks' time.
4 weeks' time to do the needful. Next para, Mr.
Somdong Zela Tilum.
Malsomdong Zela.
Tilum.
Is it there the post list?
No, my lord, I'm appearing on behalf of my senior, Mr. Albirno Anamta.
Okay. Give in writing your name, huh?
Yes, my lord.
Mr. Malsomdong Zela, learned counsel, appears on behalf of
Respondent 1 and
Mr.
3.
Mr.
Albirno Anamta.
Lalpiakno and Hamte, learned counsel, who represents respondents number 1 and 3. So, are you going to file any objection to this IA?
No, my lord.
You will not be filing.
Yes.
Are you sure?
Yes.
Because I'm going to record that.
My lord, I'm not aware of that. I'm not giving
See?
instruction.
Then don't say yes. Liberty is granted to the respondents to file objection to the IA, if so advised. List again after 4 weeks.
Oblige.
Item 13 and 14.
Lordship,
Yes.
this IA is an application for implement of the additional deputy commissioner or the administrator, rehabilitation and resettlement, Nathil district, Lordship. So the applicant had
IA is in connection with item 13 or item 14?
item 13, and I have filed the separate IA in item 14 also, Lordship.
Same kind of IA.
Same
For
matter,
impleadment.
Lordship. They are from the different villages. Item 13 is from Pangzo South and another is from Pangzo North.
No, whom do you want to implead?
Lordship, administrator. Lordship, at the time of filing this writ petition, so it was in the
Administrator. What do you mean by administrator?
may take Lordship to page 26. Administrator is the one who had published a public notice to the to the public, Lordship. May take Lordship to page 26. Administrator is the person who had issued public notice
For what?
for the acquisition of land, Lordship. This is a JICA matter, Lordship.
Under what provision? JICA? Under JICA?
Under JICA, Lordship. JICA in the sense that earlier there was a 2013 act and it was published. And after that, Lordship, the Mizoram state government had adopted the JICA matrix for the computation of the award, Lordship.
You want to implead him as respondent number 10?
10, Lordship.
How many? What about the other respondents? Who represents?
They are all represented by the...
Any objection from the respondents? Anyone?
Yes, Your Lordship, on behalf of the state, we have already filed our objection, affidavit. We have filed our affidavit in opposition.
No, in the IA.
No, Your Lordship, we do not have any objection.
Petitioners, they want to implead additional DC, come administrator for rehabilitation.
Lordship, I am for respondent number 4. No objection.
No objection. Okay, heard Mr. Johnny L. Tochong, learned counsel for the applicant, who submits that by filing this application, the applicants seek impleadment of additional deputy commissioner / administrator for rehabilitation and resettlement, Nathiel district, Nathiel, Mizoram, as respondent number 10 in the connected writ petition. Page 9, you'll see the spelling and all that. Page 9, huh? The learned counsel submits that impleadment of the said respondent is necessary for effective adjudication of the case. Stop. Ms. Vanesiami, learned government advocate, appears for the state respondents, while Ms. Baby Laldin Zwali, learned counsel, appears for the Respondent Union of India, and they submit that they have no objection if the application is allowed. Next para, considering the submissions made and on perusal of the application, impleadment of the impleadment application stands allowed as paid for. IA states disposed of. Then in the main writ petition, you write, in view of the order passed today, in IAC number 56 of 2026, petitioners to file the amended cause title in 2 sets before the registry of this court, whereafter registry shall do the needful. The amended cause title be filed within
3 days.
3 days from today. Next para. Issue notice to the newly impleaded respondent number 10, returnable by 3 weeks. Petitioners to take steps for service of notice upon the respondent number 10 by speed post within 1 week. List again after 3 weeks. Then. What about the other IA?
Lordship, they are the similar matters, but the only difference is the village, Lordship.
Yeah.
Okay, I think then same order can
Same
cover.
order, yes, Lordship.
Village, I have not indicated any village, isn't it, in the order?
Yes.
So this is again from Nathiel only.
Nathiel only, Lordship. Same order, Lordship.
Similar order in the next case also. IA 57. Then same order in the WPC also. Okay. This is also respondent number 10.
Lordship, yes.
Okay. All right.
Admission, item number 1.
May I please, Your Lordship?
Yes.
I'm appearing for the petition, Your Lordship.
Yes.
Okay. Your Lordship, as per the last order, we are still awaiting service report on respondent 2 and 4. We have also filed our rejoinder to affidavit filed by respondent 1, 5, 6 and 8, Your Lordship. The state is yet to file their account.
Okay.
Lordship, on behalf of the state respondents, we will not be filing.
All right.
And I'm appearing for respondent number 1, 5, 6 and 8, my lord.
What have you filed?
We have filed our affidavit in opposition and we have received the rejoinder affidavit, my lord.
What exactly
We
have
have filed our
you?
rejoinder.
What exactly have you filed? Tell me, Ms. Manlomsagi.
Yes, Lordship, I'm so sorry to say that.
Huh? No, what exactly have you filed? I think you have not filed affidavit in opposition. You have filed the affidavit in reply or something. I saw it somewhere. Huh?
Affidavit in opposition, my lord.
Your course title doesn't say so. That's why I'm asking you thrice.
Okay, can I look?
Are you the petitioner?
I'm the respondent, my
And for
lord.
the petitioner, Your Lordship.
No, just a minute. You're not the petitioner, isn't it?
The respondent, my
So,
lord.
when you respond to the writ petition, you respond by filing affidavit in opposition. Okay? Not affidavit in reply. You have written affidavit in reply. Just check up your file, you'll know.
Yes, my lord.
I'm not making up things, okay? It's from the file only.
Okay.
Then what they have done, they have filed rejoinder to your affidavit in reply. Of course, it's called a rejoinder. Rejoinder and reply affidavit are the same thing. But if you are the respondent, you are to file affidavit in opposition. Please keep that in mind henceforth. Now, who is this respondent number 2 and 4? Are they necessary?
Yes, Your Lordship, they are private respondents who had filed the application in the lower courts.
I see. And when did you take steps?
Your Lordship, steps were taken after the first motion itself, Your Lordship.
That is the disadvantage you have by applying online through VC. You cannot have
Yes.
you cannot have a look at the records. Let me check it up.
Lordship.
Let me check it up. Let's see. When steps was taken.
I will try to
By registered post, 13 December, January,
yes, sir.
February,
It was
March.
after the motion, Your Lordship.
This was way back in 2024.
Yes, Your Lordship.
Now,
December 2024.
it was 13 December 2024. So, I think you should
Yes,
take
sir.
fresh steps on respondent number 2 and 4.
We'll do that, Your Lordship. Your Lordship,
Yes?
interim may kindly be continued, Your Lordship.
But do you have a case? Do you have a good case?
Your Lordship, application was filed under 16(3). Your Lordship, our main ground is that the lower courts below has directed the district collector to conduct the assessment. Whereas our case is that the district collector does not have such power. 16(3) is very clear, Your Lordship, that the compensation has to be determined by the district judge itself.
Okay. What is your good name?
Ida Hul's aim, Your Lordship. Mrs.
Okay.
Ida Hul's aim. My name is
Okay.
on the court's title as
All
well.
right. Art Mrs. Ida Hun Siem, learned counsel for the petitioner through RVC. Stop also at Ms. Caroline K. Lung Oipui, learned government advocate, appearing for respondent numbers. Respondent number 10. Respondent number 10. Who submits that respondent number 10 is basically a pro forma respondent and will not be filing any counter affidavit. Stop. Ms. Rosie Manlam Sangi, learned counsel for respondent numbers
1, 5, 6, and 8, my lord.
1, 5, 6, and 8, submits that they have already filed their response to the writ petition. And before that, in the first line, through RVC, I said that, who submits that rejoinder affidavit has already been filed by the petitioners against the affidavit filed by the
Affidavit of 1, 5, 6, and 8, Your
respondent
Lordship.
numbers 1, 5, 6, and 8. The next para, it is seen that the respondent numbers 2 and 4 have not yet been served notice. since neither AD card nor unserved notice has returned back. Stop. Considering the same, the petitioner shall take fresh steps upon respondent numbers 2 and 4 by speed post within. You have somebody here who will look up to this.
We do have a local counsel.
Okay, within 3 days.
coordinate.
Within 3 days. All right. And then list the matter again after 3 weeks.
Your Lordship, if I may pray for a fixed date, Your Lordship, since we are counsels from outstation.
All right.
If I may pray for a date on the 20th of April, Your Lordship, it's a Monday,
All
20 April.
Okay.
Highly obliged, Your Lordship.
List the matter on 20th of April 2026 as paid for. Interim order passed shall
Lordship,
continue till the next date of listing.
Highly obliged, Your Lordship.
Item 2.
Your Lordship, in item number 2 also, it's a similar case, Your Lordship, I for the petitioner. Your Lordship, in this case, on the last date, we had prayed for filing rejoinder to the counter affidavit filed by the respondent. Your Lordship, we're seeking some more time for this, Your Lordship, since it's an old transmission line. We are yet to receive records.
Okay.
My Lord, we have received the rejoinder affidavit on 26/2/26, a copy of the rejoinder affidavit. I think my learned friend may have been misinformed. We have received that.
I apologize, Your Lordship.
you
The
have
information that
received-
I received is that
You have received a copy in advance perhaps, but
Yes, my Lord.
thing is that whether they have filed it or not, I don't see it in the file.
My Lord.
because there is information that I received from my colleagues. I apologize, Your Lordship, is that the rejoinder has not been filed for item number 2. And the state is also yet to file their counter affidavit, Your Lordship.
Respondent number? 2.
Respondent number 2.
They will not be filing affidavit, they say. Now,
all right, Your Lordship.
insofar as your rejoinder is concerned, probably you have served an advance copy to the counsel for the other side.
Probably,
But-
Your Lordship.
but
I
you have not filed
apologize
it.
for the miscommunication. I apologize, Your Lordship.
Heard Mrs. ACM, learned counsel for the petitioner through RVC, who submits that she may be given some more time to file the rejoinder affidavit. Stop. Mr. Silal Fagzola, learned counsel, appearing for respondent number 1, submits that he has already received an advance copy of the rejoinder affidavit. You have received it, isn't it?
Yes, my Lord, on 26/2.
On 26/2/2026. Stop. Such being the position, the petitioner to file the rejoinder affidavit within 2 weeks.
Your Lordship, this may also be fixed on the same date, Your Lordship.
We will fix on the same
20th of
date, but
April.
you file the affidavit, you file the rejoinder
Yes.
before that, within 2
We'll
weeks.
do that, Your Lordship. Your Lordship.
Then Ms. Caroline K. Lumoipui, learned government advocate, appearing for respondent number 2, submits that respondent number 2 is basically a pro forma respondent and will not be filing counter affidavit. Next para, in view of above, list this matter on 20th of April, 20th April 2026.
Yes.
As prayed for. Any
Your
interim?
Lordship, there's an interim this one
Okay,
also, Your Lordship.
interim order passed earlier shall continue till the next date of listing.
Obliged.
Highly obliged, Your Lordship.
Item
Your
3.
Lordship, item number 3 also is a similar matter. In this one, again, we have filed our rejoinder to the counter affidavit of respondent 1 to 10, Your Lordship, and we are awaiting a counter by the state.
Rosie appears for which respondent?
Respondent number 1 to 10, my lord.
1 to 10. You have filed your affidavit in opposition.
Yes, my lord.
Rejoinder also filed.
Yes, my lord.
Yes, Your Lordship.
Parties are represented by the respective councils, and it appears that the pleadings are complete except for the respondent number 11.
11, Your Lordship.
Since there's no affidavit of possession from the said respondent. Stop. Miss Caroline K. Lungoipui, learned government advocate, appearing for respondent number 11, submits that respondent number 11 is basically a pro forma respondent and that affidavit of possession will not be filed by the said respondent. In view of above and as paid for, list this matter on 20th of April 2026. Any interim order?
Interim is there, Your Lordship.
Interim order
May
passed earlier
kindly
to
be
continue
continued.
till the next date of listing. All right.
Item 4.
Again, Your Lordship, I am for the petitioner. Your Lordship, in this case, report is awaited for a few respondents, number 3, 9, 10, 23, 34, 39, 42 and 43.
And steps was
And
taken.
we have, yes, Your Lordship.
Steps was taken when? Is it like the earlier case?
I believe on the same date, Your Lordship, because it's a similar matter on the 13th of December. December.
So you should take fresh steps also in this.
We'll do that, Your Lordship.
Right.
We have
Please
filed a rejoinder also, Your Lordship,
You have filed rejoinder.
to the affidavit filed by respondent 1, 2, 4 to 8, 11 to 22, 24 to 33, 35, 36, 41, and 44 to 51, Your Lord.
Okay. Please write. Mrs. ACM, Learned Counsel, appears to RBC and submits that a rejoinder affidavit has been filed to the affidavit position filed by respondent numbers 1, 2, 4 to 8. After 4, you write 2, TO2 to 8, comma, 11 to 22, comma, 24 to 33, comma, 35 to 36, comma, 41 and 44 to 51. Ms. Rosie Manlomsani, Learned Counsel, appears for the said respondents and acknowledges the submission made by the Learned Counsel for the petitioner. Stop. Office note, however, no, what about state you appear for? Okay. Miss Caroline K. Lungoipui, Learned Government Advocate, appearing for respondent number 52, submits that respondent number 52 is only a pro forma respondent and will not be filing counter affidavit. Next para. Office note dated 19/3/2026 indicates that notice has not been served upon respondent numbers 3, 9, 10, 23, 34, 39, 42 and 43. Stop. It is also noticed that the notice was sent to the respondents by registered post with AD on 13/12/2024. And thereafter, neither the AD card nor unserved notice has returned back from the respondent numbers 3, 9, 10, 23, 34, 39, 42 and 43. Stop. Under the circumstance, the petitioner to take fresh steps for service of notice upon the said respondent by speed post within 3 days. List the matter again on 20th of April 2026.
There's an interim again, Your Lordship.
Interim order passed earlier shall continue to the next date of listing.
Item 5.
Again, Your Lordship, I am for the petitioner. State is yet to file their affidavit, Your Lordship. We have filed our rejoinder to the affidavits by the private respondents.
All the private respondents are represented?
Yes, my lord. One, two, five. Maka, 60.
How many respondents are there in this case?
There are 6 respondents, Your Lordship.
6. And the state is
1 to
respondent
5.
number?
Number 6.
State will be respondent number?
Respondent number
6.
6, Your Lordship.
Okay. Parties are represented by the respective councils and pleadings have been exchanged except for respondent number 6. That is the Deputy Commissioner, Kolasip District, Mizoram. So Ms. Caroline K. Lumapui, learned government advocate, appearing for respondent number 6, submits that respondent number 6, being a pro forma respondent, will not be filing counter affidavit. In view of above, let the matter be listed on 20th of 20th of April 2026. As per
Interim, Your Lordship.
interim order passed delay shall continue till the next date of listing. All right.
I would like to lodge.
Item 7.
May I please, Your Lordship?
My lords.
Yes.
My lord, in this case, Lordship, I am filing this IA, my lord, seeking, my lord, modification vacation of the order dated 26/8/2025 passed by this honorable court, my lord. And in fact, my lord, on the last occasion, your lordship has observed that, my lord, effort shall be made to dispose of the main writ application, my lord.
So,
that was done.
So let us hear the main writ petition then.
Lordship.
Let
Lordship.
Mr. Jordan make the submission, then you can
My
respond.
lord. My lord.
My lordship. My lords, in this case, primarily, my lords, we are raising one point only, my lords.
Sorry?
We are raising only one submission, my lords.
What is that?
That is violation of principles of natural justice, my lords.
Okay.
And what we are challenging is the order at page 49, which is an impugned order dated 25th February 2025, my lords. It is an order passed under section 127.
Page 49?
Yes, my lords, page 49.
Just a minute. Page 49.
49.
This is an order dated 25th of February.
Yes, my lords.
2025.
Yes, my lords.
An order passed under section
127, subsection 2.
So you'll have to somehow, clarify, I mean,
Yes.
sort of, like pinpoint what is that section, because
Yes, yes, my lords.
it is not every day that this court comes across this income tax matters.
Vast act also.
So that's why.
Yes. My lords, if your lordship sees page, the income tax section.
Section 127, 2.
Yes. Your lordships has it?
127. Power to transfer cases.
Yes, yes.
127.2. Okay. Yes.
My lords, if I may read.
Yes.
From subsection 1.
Yes.
The principal director general or principal chief or chief commissioner or principal commissioner or commissioner may, after giving the SSE a reasonable opportunity of being heard in the matter wherever it is possible to do so, and after recording his reasons for doing so, transfer any case from one or more assessing officers subordinate to him, whether with or without concurrent restriction, to any other assessing officer or assessing officers, whether with or without concurrent jurisdiction, also subordinate to him. This is one, my lords. 2, where the assessing officer or assessing officers from whom the case is to be transferred and the assessing officer or assessing officers to whom the case is to be transferred are not subordinate to the same. My lords, in my facts, it is being transferred, sought to be transferred from, my lords, Silchar to Guwahati. My lords, they are different commissioners. So, my lords, are not subordinate to the same principal director general or principal chief commissioner or principal commissioner or commissioner. My lords, A, where the principal director general or principal chief commissioner or chief commissioners or principal commissioners or commissioners to whom such assessing officers are subordinate are in agreement, then the principal Director General or Principal Chief Commissioner or Chief Commissioner or Principal Chief Commissioner or Commissioner from whose jurisdiction the case is to be transferred may, after giving the assessee a reasonable opportunity of being heard in the matter, wherever it is possible to do so, and after recording his reasons for doing so, pass the order. My lords, B for completeness I'm reading, and I'll just refer to those, my lords, in brackets as commissioner, where the commissioner aforesaid are not in agreement. The order transferring the case may similarly be passed by the board or any such principal director general or chief commissioner or principal chief commissioner or principal commissioner or commissioner, as the board may by notification in the official gazette authorize in this behalf. So, my lords, under 127(2)(b, there are two necessities, my lords, as per our case. We are saying, my lords, one is definitely that you need to give us an opportunity of being heard. Thereafter, pass a reasoned order by recording the reasons for passing this way or that way the order. And thirdly, my lords, a preliminary to all these conditions is an agreement between the two principal commissioners. That is, my lords, I am under Shillong. I was under Shillong. Now they've wrongfully transferred me to Guwahati. These are two separate PCITs, as they call it, Principal Commissioner of Income Tax. So, my lords, this transfer to, my lords, to further whatever investigations under the IT Act, Income Tax Act, my lords, whether they want to centralize meaning, my lords, they want to transfer my jurisdiction to another jurisdiction, these conditions have to be first met, my lords. Thereafter, my lords, the statutory authorities, they are there if I have to say anything on merits. So, my lords, under this impugn order was passed.
First thing is, transfer is possible.
Possible.
Transfer can be done.
Yes.
But subject to these things.
Conditions.
That the SSC has to be given reasonable opportunity of being heard. Then reasons have to be recorded.
Yes. And there has to be an agreement, my lords.
That agreement part, from where did you say? From where do you say that agreement has to be there?
2A, my lords. And my lords, there is a direct judgment on this.
Are in agreement.
Yes.
Then so and so, so and so, so and so, so and so.
Yes, my lord.
Is to be transferred May after giving necessary reason for being heard in the.
My lords, this agreement, there is a direct judgment. It's a two-pager judgment passed by Justice Ranjan Gogoi and Justice Sapre, 2017. I'll cite that also, my lords.
Who is that?
My lords, if I may pass it.
Cite it now. Let us see.
My lords, similarly in this case, my lords, a writ petition was filed before High Court of Madras, Honorable High Court of Madras. And the order passed therein was upheld. It was further challenged before the Honorable Supreme Court, and your lordships may have it from para 2. For the purposes of the appeal, it will be necessary to note the provisions of section 127(2)(a) of the Income Tax Act. My lords, I will not repeat. At para 3, as the income tax assessment file of the appellant assessee has been transferred from one assessing officer in Tamil Nadu to another assessing officer in Kerala, and two assessing officers are not subordinate to the same Director General or Chief Commissioner or Commissioner of Income Tax under Section 127(2)(a) of the Act, an agreement between the Director General, Chief Commissioner or Commissioner, as the case may be, of the two jurisdictions is necessary. Para 4, counter affidavit filed on behalf of the revenue does not disclose that there was
Just a minute.
I'm sorry.
Agreement is necessary. Prior to that, since assessing officers are not subordinate to the same DG.
Yes.
Or supposing they are subordinate to the same DG, then
my lords,
agreement is not required.
My lords, 2B will come, and agreement, my lords, it says
2B. What does the 2B say?
2B, my lords, my lords, it says that where the I'm sorry, my lords,
are not in agreement.
Are not
order
in
transfer may by the board.
By the board.
What do you mean by the board?
My lords, this
Who
is
the board?
CBIC, Central Board of CB, this would be Central Board of Direct Access, my lords. There is a separate board, which Mr. Chetia could also clarify, my lords.
So,
Yes.
if the principal chief commissioner or chief commissioner do not come to a consensus,
Yes.
transfer can still be made with the, but by the board.
By the board, my lords.
Order passed by the board.
Yes. And in our, my lords, writ, in our petition, we have raised this issue. In the counter, this has not been, my lords, answered. Neither, there is no specific denial. So, my lords, in this judgment, in this small order, I would say, my lords, if your lordships, if I may read.
So, main thing is the agreement, isn't it?
Yes.
That's regarding what I was stressing upon is the
Yes.
The two assessing officers are not subordinate to the same Director General.
Yes.
If they are not subordinate to the same Director General, then this thing happens.
Yes.
But if they are subordinate to the same Director General, then what happens?
My lords, if they are not, my lords, then the board, that would mean a disagreement, my lords. And therefore, my lords, 2B would come, where the principal Director General or Chief Commissioner or Principal Commissioner or Commissioner aforesaid are not in agreement. The order transferring the case may similarly be passed by the board. So, my lords, if they are not in agreement, the board will pass, is my understanding.
No, if they are subordinate to the same Director General,
Yes.
where's the question of there being disagreement?
Yes, yes, my lords. In our case, it is not. Your lordships is right. That agreement we need not be there. 127 subsection 1 would follow then. Your lordships has that? 127(1).
Yes.
My lords, it says, my lords, that the commissioner, after giving the assessee a reasonable opportunity of being heard in the matter, wherever it is possible to do so, and after recording his reasons for doing so, transfer any case from one or more assessing officers subordinate to him to any other assessing officer.
So the person who transferred
Yes.
from Silchar to Guwahati
Yes.
to the assessing officer of those two places.
Yes.
These two assessing officers of those two places are subordinate to him?
No,
or
no,
not?
my lords, no.
They are not.
They are not. Silchar is, my lords, subordinate to the PCIT Shillong.
Then one will not apply.
Yes, yes.
127 one will not apply.
Your lordships is right.
Then 127 2.
2. Therefore, the impugned order passed under 2.
Agreement is there. But you had read 127 1 for the purpose of saying that principle of natural justice is be followed.
No, 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 my lords. That same condition applies in 2 also.
2 also?
Yes, yes, yes.
Okay.
2A specifically. 2 says, my lords, can I read again?
Yes, the last part.
Yes, my lords. Where the, I'll just read 2, my lords. Where the assessing officers or assessing officers from whom the case is to be transferred and the assessing officers to whom the case is to be transferred are not subordinate to the same Director General or Commissioners, my lords. I'll put it that way. A says, where the commissioners to whom such officers are subordinate are agreement, then the commissioner from whose jurisdiction the case is to be transferred may, after giving the assessee, this part, my lords, may, after giving the assessee a reasonable opportunity of being heard in the matter, wherever it is possible to do so, and after recording his reasons for doing so, pass the order. This bit, my lords.
Talks about agreement here.
Yes, yes.
2A.
Yes. Because, my lords, now the jurisdictions are different. 2 different commissioners.
Is there an agreement?
My lords, we have raised it in the counter when, my lords, the income tax department had answered. They have not answered to this effect at all.
Okay.
Therefore, my lords, since there is no specific denial, it can be taken as an admission, my lords. But nonetheless, my lords, that agreement we are putting aside for a moment. Your lordships may just see how the impugned order is passed. My lords may have page 47, which is a prequel to, my lords, the impugned order, the show cause notice.
47.
Page 47. My lords,
Yes.
may I read?
Yes.
It has been informed by the PCIT Central Guwahati that a search and seizure operation under 132 of the IT Act was conducted in your case on 23rd January by the Deputy Director Income Tax Guwahati in your case. In this regard, a proposal for centralization of your PAN has been received in office in pursuance of the reasons cited in para 1 above. As per the CBDT's existing instructions, your case is proposed to be centralized for the purpose of the centralized assessment. Accordingly, your PAN is to be transferred to the office of DCIT Guwahati under PCIT Guwahati. So, my lords, Guwahati is separate under 127 of the IT Act. 4. I hereby propose to pass an order under 127 of the IT Act in your case. Your objections, if any, may be filed within 5 days from the receipt of the notice. My lords, the very next day is the order being passed.
This is letters dated?
My lords, 24/2.
And next day is the order, 25/2.
Yes. Now, my lords, there is one document I have to show your lordships also, my lords. At page 50.
Yes.
My lords, at page 50, because, my lords, what Mr. Chetia had said is that via an email, I had communicated and I had said, I don't object to the centralization.
50, page 50.
Page 50, yes, my lords. Your lordships may have page 50.
Yes.
Somehow, my lords, this is dated 25th February. Your lordships. This is 25th February, the same date when the impugned order was passed. And I'll take your lordships straight to para 5, which is the relevant part.
Yes.
As the show cause notice was already issued by the PCIT Shillong on 11 February 2025 for compliance, the DIN letter number issued on 24th February is hereby amended such that your objection to the said proposed transfer from Shillong to PCIT Guwahati should reach the undersigned by 3:15:00 hours of 25th of February 25. Your personal presence is not required and online submission of your objection, if any, would be considered sufficient. I won't read further, my lords.
This has been modified.
Yes. Now, my lords.
Take into account
Yes.
that a show cause notice was issued to you on 11/2/2025.
Yes.
That is why.
That is why. Now, my lords, there is two interesting facts I want to point out. There is no, my lords, show cause notice of 11th February. If your lordship sees the order at page 49, the impugned order.
Yes.
Yes, my lords. After the chart, my lords, it says, the order is passed as per the proposal received from Guwahati, white dated 5th February, in view of the instruction of CBDT, dated so and so, instruction issued, dated 18/9/2020, and also on the satisfaction that centralization of this case to DCIT Guwahati is necessary for the purposes of coordinated investigation and to examine all the interlinking evidences gathered in the case of Abdul Noor and Jakir Ahmed. In this regard, no objection was called from the FSSE, white din and letters dated 24th February 25 and 25th February 25. But no response is received in this office till date, whereupon it is presumed that the SSE has no objection to the proposed transfer. So, my lords, they themselves say that we have not received anything, therefore we are presuming that the transfer will be made.
What is the second letter? 25th of February?
My lords, this is we are supposing that it is the letter at page 50.
50?
Yes. So, my lords, 24th February, you say we are giving you 5 days notice, but the very next day my lords, issue the impugned order and also another letter whereby they have modified the timing, saying that by 3 o'clock you submit.
Where is that response? They say that
Yes.
you have made that you have no objection.
Yes, my lords.
Where is that?
Your lordships may have the counter affidavit of the department, affidavit in opposition. Page 14 of the affidavit in opposition. And your lordships may just record the time of my alleged reply.
546.
546. And I've asked my lords, the client, whether this email is hers or has she given such an no objection. My lord, she says I'm not aware at all of this email. For the first time, it's come in these proceedings. And your lordships, the impugned order itself says that we've not received anything. Therefore, we are presuming. It is almost a dangerous trend, my lords.
So,
Yes.
you say that the principles of natural justice not followed. You are not heard. Objection was to be given by you. Timing
Yes.
was 5 days.
Yes.
But the very next day they passed
Yes.
the order.
Yes.
And as per the affidavit of opposition, purportedly you had given your, you had agreed to the transfer.
Yes.
The email timing is what?
5:46
5:46
PM, my lords.
And time given was
3.
to you was till 3 o'clock.
Yes. Your lordship knows the office hours. It is quite strange. And my lords, assuming if it were true that it was my no objection, the impugned order itself reflects that I had not given any response. My lords, apart from this, my lords, I want to satisfy your lordship so far as the contention raised of parallel proceedings. My lords.
Parallel proceedings.
Yes, my lords. What has happened
How is
is, my lords, today there is an order of penalty. There is an order of penalty, my lords. We are challenging that before the statutory authority, pending. This order, my lords, which is passed under 127 of transfer, based on which the order of penalty was passed, for which proceedings are pending. My lords, this is an unappealable order under the Act. That's why we've come before your lordships in a writ.
Which order is not appealable?
127, my lords, which we are challenging today.
127(2).
Yes.
Not appealable.
Not appealable. It is, my lords, as per the Act under section 246A. I'll take your lordships through that.
Revision.
My lords, appealable orders before the Commissioner of Income Tax Appeals. Your lordships.
246A.
246.
What do you say about 246A(1)(q)?
My lords, I'll answer that, my lords.
246.
Yes.
Just 246 or 246A?
246A, my lords.
Okay. Appealable orders before Commissioner.
Yes. Your lordships is right. This is the order which is being pending before the statutory authority, my lords. 1Q, your lordship said. This is the order which is pending. That is the order passed under section 271D, my lords. Your lordship says Q, which is an order imposing a penalty under chapter 21. If we look at chapter 21, my lords, it is a penalty. My penalty which is imposed is 271DA under chapter 21.
No, this order which you have shown me under 127(2).
Yes.
This is only an order of transfer.
Yes.
There is no penalty as such here.
There is no penalty.
This is only a transfer.
Yes.
You mean to say that apart from this transfer order, you have also challenged the penalty?
Penalty.
Penalty has been imposed upon you?
Yes, my lords.
Where is that?
My lords, this is that. Your lordships.
271DA.
Page, yes, my lords, page 52 of the writ petition.
271DA can be challenged in
Yes.
appeal?
Yes, my lords, it can be.
it says chapter
21.
21.
Yes.
So, section 127, subsection 2 is also within chapter 21. Is it not?
No, my lords. It is not a penalty, a transfer order.
Hmm. 246A. It is not a penalty, no doubt, but it comes under chapter 21.
No, my lords. It does not. Is a humble sufficient.
Okay, 246. Okay.
Yes.
46. All right. You are referring to this only.
Yes.
That 127(2) cannot be challenged. So you came before a
the
writ court.
Yes.
But in respect of the penalty, you have challenged that before the thing.
Correct.
To the appellate authority.
Correct.
And that is why you say that there's a parallel proceeding.
My lords, the department says, I am saying, yes, there is a proceeding, but I cannot raise this issue, my lords, before the CITA. That is the problem. Now, my lords, suppose, my lords, your lordships were to allow this petition and set aside the impugned order. My lords, then I can say and make it a ground in those proceedings. But I cannot challenge that transfer, my lords. It cannot be set aside by the CITA. It is not within their jurisdiction. Therefore, your lordships, in that judgment, Noor Islam, there also, my lords, a writ was filed before the High Court Madras, what I've placed before your lordships.
No, after the transfer, the penalty order had been passed.
Yes.
What is the time span between the two?
My lords, your lordships, we've put the impugned order of penalty at page 52. It is passed on 26 March, which is exactly after a month.
After a month.
Yes, my lords.
Now, after the penalty, what happens? You can challenge that.
Yes, I've
in appeal.
challenged it. I've challenged it in appeal, my lords. And strangely, my lords, this is what I had brought before this honorable court when we had filed this petition, is that despite there being a penalty imposed, despite that conclusion of proceedings, time and again, my lords, the income tax department is sending us notices of summons, saying you come before us, despite the proceedings culminating in a final passing of a order of penalty, which we are fighting, my lords. They are continuously coming up with notices, come before us, put this document, that, the raw document, my lords.
No, if you have filed an appeal, correct?
Yes.
Against the penalty.
Yes.
What is the stage of that proceeding?
My lords.
And why would you come and also include that in your writ petition?
No, my lords, we have to come with clean hands, your lordships. We are just trying to show that the order, after the order of transfer being passed, what the department has done thereafter, my lords. What proceedings? We are not challenging the impugned order of 26th March, my lords. Even though we have termed it as impugned, we are not assailing it. We are only assailing the 25th February, my lords.
No, come to your prayer portion at page 26.
Yes.
Prayer 1. Roman 1.
Yes. No, your lordships is right. We've put it.
Costing of 25 to 25, 26 to 25, and the investigation proceedings.
Yes. My lords, this is my omission, my lords. 26 is pending. So, my lords, we will not be challenging these orders. Just 25th.
Well, you can inform the court that we have also done this.
Yes.
It's pending.
Yes.
But then again, to challenge that, setting aside of that thing would mean that it's a parallel proceeding. In your case also. Because you are actively taking up that matter there in the appellate forum.
Yes.
While you are also filing this writ before this court.
So, my lords, we can we are forfeiting, since it's included in a prayer, we're forfeiting insofar as.
Now, you tell me what will happen supposing this court interferes with this 25 to 2025.
Yes.
What will happen to this 26-325?
My lords, since it's being challenged before the authorities, we will make it a ground insofar as the 25th February, if this honorable court interferes insofar as the order under 127. We will say, my lords, that we will make it a ground. That proceedings will go on, my lords, ultimately. It will go on its own legs, my lords. And there is nothing which stops the department from reissuing and restarting the proceedings again, my lords.
See, things have happened. You see, 25-2, then 26-3 has happened.
Yes.
The appeal is down. Now you want to take us back in time and say, no, 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 the first transfer of this to from Silchar to Guwahati was wrong. You have not heard us.
Yes.
Supposing we consider that and accept that and set aside the thing, then what will happen to the remaining
My lords,
the
may I
penalty and all that?
I understand what your lordships is raising.
There will be no route. The beginning, the transfer itself was void ab initio. So
Yes. My
this
lords,
is what
yes. My lords, it will have an impact on the proceedings, no doubt.
it will have.
But that adjudication will happen by the appropriate authority because, my lords, because I cannot raise this issue.
What bars you from raising that issue?
My lords, the order under the section under statute under 246A, my lords. If we raise it, it will not be dealt. It will be closed. It will be closed, my lords. It is not appealable. It is not within my jurisdiction. Therefore, I am upholding the penalty. You should have filed a writ. This is the response we'll get from the department, my lords.
You did not come immediately before this court.
My lords,
we waited for the penalty.
It is true, my lords, in 1 month they've passed. And frankly, my lords, these proceedings before the Commissioner of Income Tax, your lordships would be aware, is by my lords certified chartered accountants. Whatever proceedings, my lords, they've taken in their legal knowledge, my lords, unfortunately. And I may suggest, my lords, lastly, I'll close with this, my lords. If your lordships were to interfere, your lordships may say this, the proceedings that are ongoing, that may go on its own way, and this may be considered at the appropriate time if raised. That is all, my lords.
But if there's a bar, can we still add something to that? But show me the bar. How do you say this?
My lords.
Bar.
My lords, 246A. There is no such bar, but my lords, it is not within the appealable orders section. 246A, my lords.
Order was under 127. Correct?
Yes, ma'am.
Now, this judgment which you just you have relied upon, what does it? What is the ratio laid down here?
My lords, basically that, my lords, one is that the agreement is a necessity insofar as when the commissioners are of different jurisdiction. And basically that, my lords, just because there is absence of denial, that cannot be presumed as a consent. Your lordships may have the para 4.
So, in this case, perhaps that penalty did not, the order of penalty was not passed yet. In the above circumstance, we hold that the transfer of the income tax assessment file of the appellant from so-and-so is not justified, authorized under section so-and-so.
My lords, your lordships has said may have been passed. I believe yes, my lords. May not also, my lords. It is not clear. Because, my lords, when the order of the Honorable Supreme Court came, it was 2016, and the order of the Madras High Court came on 2015 March. And proceedings being time-bound under the IT Act. Oh, my lords, your lordships may kindly put it for some time. I'll just also see and dig some more if your lordships permits, just to be on the safer side. If your lordships permits, or else this is our case, my lords.
May do that. Let me hear, Mr. Chetia.
Yes, lordship, may I please? Please, Your Lordship. My Lord, in this petition, petitioner has challenged mainly the two orders. First, the order passed on 25/2, that is the transfer order, and secondly, the order dated 26/3, that is the penalty order. And so far as the penalty order is concerned, my Lord, they have already prepared an appeal which is pending. So that, my Lord, my humble submission is that, my Lord, parallel proceeding is not allowed, and in fact, this honorable court has held in number of cases that once the SSC filed an appeal, thereafter, my Lord, 226 remedy is not available for the SSC. And, my Lord, with regard to the, my Lord, the transfer order, Your Lordship has already gone.
Appeal is filed under which provision?
My Lord, it is memo of appeal at page 80, my Lord. It is filed under section 247, my Lord. I am just giving the appropriate.
Page 80.
Page 80.
Page 80, my Lord. That is their memo of appeal, my Lord.
Challan.
Lordship. And my Lord, the appeal was filed on 26 March, page 82, my Lord. At the top, Your Lordship will see. And the amount disputed is, my Lord, page 83, 2 crore 88 lakhs, my Lord. So this was the appeal, my Lord, that is pending, my Lord.
No, appeal filed under what provision?
And that is, my Lordship, under section, my Lord, 246, my Lordship. I am just referring to group sections. Yes, Lordship, it's under section 247, my Lord.
My Lords have
246A, my Lord.
82, page 82.
246A.
Yes.
Lordship.
Is it that particular section I referred, 1Q?
Yes. My Lords, it's not
268.
specifically stated because these are faceless digitized proceedings. Mr. Chetia will also say concur on that. So, my Lords, all we've said is 246A at page 82. Though Your Lordships is right, under Q.
So, Lordship, since the appeal is pending, my Lord, so present petition, my Lord, by challenging the same impugn order, my Lord, that is not permissible, my Lord. And in fact, my Lord, number of judgments of this honorable court has categorically stated to that effect, Lordship.
Okay.
So far as, my Lord, the order dated, my Lord, 25/2, that is the transfer order, my Lord.
Yes.
So, Lordship, already, my Lord, gone through the relevant section, that is section 127, my Lord. And section has clearly stated that wherever it is possible, Lordship may kindly, again, my Lord, visited the section, my Lord, 127.
Yes, 127.
Yes, Lordship. 127, subsection 2, Lordship.
Yes.
2A, where the Principal Director General or the Principal Chief Commissioner or Principal Commissioner or Commissioners to whom such assessing officer or subordinate are in agreement, then the Principal Director General or the Principal Chief Commissioner or Chief Commissioner or the Principal Commissioner from whose jurisdiction the case is to be transferred may, after giving the associate reasonable opportunity of being heard in the matter, wherever it is possible to do so, and after recording his reason for doing so, pass the order. So, my Lord, in fact, my Lord, opportunity was provided to the SSC, my Lord, and SSC has already given her consent, Lordship. In the, my Lord, the email, my Lord, in our affidavit, Lordship. The Lordship has gone through it, my Lord. And, my Lord, everything is online nowadays, my Lord. It has been given, my Lord, opportunity to submit her reply, which she has filed online, my Lord. And that was received on, my Lord, 26, my Lordship, on 25/2 itself, Lordship. In our affidavit, date, time and email address are also there, my Lord. It was from the email address of the, my Lord, the petitioner, my Lord.
See, Mr. Chetia, if you come to page 47, annexure 4.
Lordship.
This is a notice, perhaps?
Lordship.
You have stated that you may file your objection within 5 days.
Yes, Lordship. Initially
5 days from 24th of February.
Yes, Lordship.
But then order has been passed the next day.
Yes, Lordship. Thereafter, my Lord, before that, my Lord, page 50, my Lord, another notice was issued, Lordship. Here it says, my Lord, the para 5, which has already been referred to, my lord, it was, the so-called notice was already issued by the so-and-so on so-and-so for compliance. The dean so-and-so issued on 24th February 25, which is hereby amended such that your objection to the same proposal transfer from PCIT Shillong to PCIT Central Guwahati should reach the undersigned by 15 hours of 25 to 2025. So it was amended, Lordship.
Okay, now can you show me this notice of dated 11/2/2025?
That is not on record. That is not related to the, my lord, 127, my lord. 127 is, my lord, the next notice, Lordship.
See, Mr. Chetia, you are supposed to give some time to hear them, objection or whatever they have to, you have to give them some opportunity. Now, as per your notice, you have given 5 days time, well and good, but then you proceed to pass the order the next day, and you say that some sort of consent was given by the
yes,
SSC.
Lordship, that is on record, Lordship.
But that has been, I think, disputed.
No, my lord. When my lord, by filing an affidavit, we are saying, my lord, by disclosing the official email ID of the petitioner, my lord, it was come from her email account, my lord, and it was delivered to the official, my lord, website of the Income Tax Department, my lord. Thereafter, my lord, that cannot be disputed, my lord. And once they raised a dispute, my lord, then, my lord, the maintainability of the requisition is, my lord, it has to be considered, lord. Because it is on affidavit, my lord. On affidavit, we are saying we received the email from the email address of the, my lord, petitioner, my lord. That was received, my lord. Your lordship may kindly see page 14 of my affidavit, annexure. That is typed copy. That it was, my lord, received in the official website of the Income Tax Department. That is, my lord, at 6:29 p.m. on 25/2/2025. That is the system of Income Tax Department. Your lordship may kindly note, my lord, the first line, my lord, after the dates and time, my lord, in my typed copy. webmail.incometax.gov.in/IWE static so and so lordship. So it was delivered in the official, my lord, web portal of the Income Tax Department, my lord. How it can be denied by the petitioner, my lord? And in fact, lordship, the agreement of both the commissioners, that was established from the order itself, my lord. And in fact, the notice, my lord, that was issued, my lord, at page 47, that itself discloses that at the request of the PCIT Guwahati, the PCIT Shillong has proposes to transfer the PAN jurisdiction. So both are in agreement. That is not in dispute, my lord. And in fact, my lord, the order at page 49.
See, Mr. Chetia, one thing. If you say that, okay, this mail was received from the SSC, that's one thing. But the other thing is this letter at page 50, by which you have modified the timing for the reply.
Lord.
See, the reasoning given by you is that you have already received a show cause notice back in time, that is on 11th of February. Therefore, we are curtailing the time and you reply by tomorrow, like that. So,
Lordship,
you only say that 11/2/2025 is nothing, it has nothing to do with the transfer.
Lordship, may I submit, my lord? My lord, may I read para 5 once again, page 50, lordship. As the show cause notice was already issued by PCIT Shillong on 11/2/2025 for compliance, the Dean letter number so and so issued on 24th February 25 is hereby amended. So, my lord, amendment has been made to the letter dated 24th February 25. It was not, my lord, the amendment was not made to the, my lord, so cause notice dated 11/2, my lord. That was for different purpose.
No, I am not saying that.
My lord.
I just wanted to know what is there in 11/2/2025.
That is not on record, lord.
No, it appears that according to you, you are saying that you are already aware about this on 11/2/2025.
Yes, my lord.
So that's why we are amending this, the show cause notice from 5 days to just 1 day.
Lordship,
so are you saying that on 11/2/2025, the SSC was aware of the fact that you intend to transfer the case?
My lord, I'm not making that submission, my lord. My submission is, my lord, that notice was issued on 11 to 2025 for filing reply by the petitioners, my lord. And my lord, in the meantime,
For a reply only, isn't it? A reply.
Lordship.
Reply to what?
Reply to the allegations made in the said so-called notice, lordship. And my lord,
No, we are talking about the transfer. The transfer issue was not there on 11 to 2025.
yes, lordship, it was not there.
That issue was not there. But as per section 127, you have to give them some opportunity also.
Lordship, section 27 comes by notice dated, my lord, 24/2, my lord, page 47. So, this is the notice regarding transfer of PAN jurisdiction, my lord, page 47. My lord, because, my lord, there are various, my lord, proceeding initiated against, my lord, petitioner, my lord. So, my lord, several notices were issued, my lord, under different sections, my lord, different provisions of Income Tax Act. And, my lord, so far as transfer of the PAN jurisdiction is concerned, that is, my lord, notice dated, my lord, 24/2, page 47. My lord, in the meantime, on 25/2, we have amended that notification, my lord, 25/2. And we request the petitioner to submit her reply by the next date on 15 hours, on the same date. Which, my lord, it was delivered to the, my lord, web portal of the department on, my lord, 25/2 at 6, in my affidavit, lordship, I have already shown. That was delivered in the official address of Income Tax Department at 25/2 at 6:29 p.m. So, my lord,
So, Mr. Chetia, let me sum up your argument. Number one, you are saying that since appeal is pending, regarding penalty, you cannot have two proceedings, simultaneous proceedings.
That is not permissible.
So, on that ground, that prayer should not be entertained.
Lordship.
Now, secondly, insofar as the notice given for transfer, you say that notice was given, giving 5 days, but later on it was modified to 1 day, and on 25th itself you received an email saying that the SSC has no objection. So, on that basis, we had proceeded.
Lordship, in fact, Lordship, once the petitioner has given her consent, my lord, thereafter that cannot be disputed in a writ proceeding, my lord, and that too, my lord, by saying that, my lord, she has not given the email, my lord, that was somebody else, my lord. That is, my lord, my humble submission, my lord, that cannot be decided, my lord, in 226, my lord.
Okay, regarding 127 order,
my lord,
can it be raised in the appellate forum?
Lord, that also, my lord, I have to, my lord, I have to go through it, my lord. But prima facie, my lord, I do not found it is reflected in the, my lord, appellate provision, my lord.
Can this court say that, okay, person has filed an appeal against the penalty, so while the authority, while considering the appeal, shall also take note of the grievance projected regarding the transfer?
My lord, under the appellate provisions, my lord, since, my lord, this order is passed by the principal commissioner, my lord, so, my lord, appeal will not lie before the, my lord, commissioner appeals, my lord. It should be, my lord, before the tribunal. Any order passed by the, my lord, principal commissioner or chief commissioner, that will lie before the tribunal only, under 252, my lord. However, my lord, from that provision...
Appeal under 246A is before the...
Before the, my lord, commissioner appeals, my lord.
Commissioner appeals?
Lordship. So, before commissioner appeals, my lord, appeal will lie, my lord, against an order passed by subordinate authority to the commissioner, my lord. Not the joint commissioner or above the rank. In that case, it will lie before the tribunal, my lord.
Tribunal.
Lordship.
Under what provision is that?
My lord, it is 253, my lord.
253.
Lordship. (253)(1), my lord, against the order passed in appeals, my lord, and 253, lordship, 2, subsection 2, my lord, that is against the order passed by any principal commissioner or commissioner. Now, my lord, subsection 2B, my lord, subsection 1B.
1B.
My lord, 1C, man. That, however, my lord, I do not find section 127, my lord.
127 is not available.
Not available, lord.
And thing is that whatever is possible or permissible, I think the relevant sections are reflected.
Yes, yes, my lords.
My lord.
So otherwise, why should they reflect the sections?
Yes, lord. Yes.
The reason behind reflecting of
Yes, yes.
reflection of sections means they are very specific.
Lordship, lord.
Order
To that
passed under
extent, my
this.
lord, Yes, lord.
So
that's correct.
So only
So
thing is
probably, my lord,
that is why the writ court.
Yes,
That's
lord.
why they have come before the writ court.
Lordship, lordship. To that extent, my lord, I do not object, my lord. My objection is, my lord, since they have already given her consent, my lord, it is, my lord, on record, my lord, by way of an affidavit, we have brought it on record, my lord, that she has already given an consent, my lord. So thereafter, my lord, my humble submission, your lordship may not interfere with the said order, my lord, dated, my lord, 25-2, my lord, by transferring the pen jurisdiction. And most of, my lord, it was on agreement of, my lord, two commissioners, my lord, PCIT Shillong and PCSE Guwahati, my lord. And, my lord, for the purpose of, my lord, administrative side, my lord, it was transferred.
Mr. Chethi, how do you say agreement was there?
My lord, because the order itself is reflecting, my lord. Your lordship may see page 49, the impugn order, my lord. In exercise of powers conferred upon me by subsection 2 of section 127 of the Income Tax Act and all other powers enabling me in this behalf, I, Principal Commissioner of Income Tax, Shillong, hereby transfer the jurisdiction of the case mentioned below concerned on the group case of Abdul Noor and Jakib Ahmed, particulars of which are mentioned in column 2 and 3 of the schedule given hereunder from the assessing officer mentioned in column 4 to the assessing officer mentioned in column 5 on the following table. Thereafter, after the table, your lordship may see, the order is passed as per proposal received from PCIT Central Guwahati. So, lordship, a request was made by PCIT Guwahati, my lord, to transfer the case under his jurisdiction because, my lord, it is a group case, my lord, that Abdul Noor and other persons, their pen are with PCIT Guwahati, my lord. That's why it was, my lord, requested to transfer the pen, my lord. And accordingly, PCIT Shillong, after giving the opportunity, my lord, to the petitioner, has transferred the pen jurisdiction to Guwahati, my lord. So it is a group case, my lord. The background is, my lord, certain cash amount was recovered, my lord. That was, my lord, handed over to the, my lord, petitioners by the court of, my lord, the trial court, my lord. And thereafter this proceeding was initiated, my lord. And it was a group case, my lord, since two other persons span jurisdiction within the PCIT Guwahati, my lord. Therefore, it is required to also transfer the case of the petitioner to, my lord, PCIT Guwahati. So my humble submission, my lord, with this, my lord, documents, my lord, and in view of the, my lord, the consent given, my lord, by the petitioner, my lord, as he doesn't have any objection to that effect, my lord, this pen was transferred, my lord. And subsequently, my lord, by saying this, it was not sent from her mail or she doesn't know anything about that. That is, my lord, in my humble submission, my lord, that may not be, my lord,
okay.
Lordship taken care of, my lord. And under 226, that cannot be decided also. So my humble submission, my lord, this petition may be dismissed, my lord.
Okay.
That is my humble
submission. All right. You have a quick response?
One short response, my lords.
I'll come back in 5 minutes.
Oh, my lords.
All right, we'll give you a response. I'll hear him for a short reply, then I think you can close the matter.
Lord.
I'll just rise for 5 minutes and come back.
My lord, my lord.
So, my lords.
Yes.
Coming back, my lords, I just want to reiterate one point only. My lords, so far as the email, assuming, my lords, I have sent the email, and admitted. My lords, when the impugned order was passed, it did not record such consent, nor was it the reason for passing of the impugned order. It categorically says that no objection was called for, but no response is received in this office. Therefore, presume that no objection to the proposed transfer. And my lords, the elements of my lords, principles of natural justice, giving me some hearing, my lords, and passing of a reasoned order, my lords, that I did not reiterate, but I may only state. So, my lords, even if the disagreement is to be presumed, that is all.
Okay. Please, right. Heard Mr. Jordan Rohingthanga, learned counsel for the petitioner, and Mr. S. Chetia, learned standing counsel, income tax, appearing for the.
I am for 2 to 10, Lord.
Respondent numbers 2 to 10. Stop. The petitioner has invoked Article 226 and 227 of the Constitution of India in filing the instant writ petition. Praying for interference of this court to the order dated 25/2/2025, issued under Section 127 (bracket 2) of the Income Tax Act, 1961. Bracket IT Act. Whereby the jurisdiction of the petitioner's case has been transferred from ITO Ward 1, Silchar, to DCIT Central Circle 1, Guwahati. Stop. The petitioner has also challenged the order dated 26/3/2025, passed under Section 271, capital D, capital A of the IT Act, by which penalty of rupees 288,03970 has been imposed on the SSC. Stop. Additionally, the petitioner has also sought for a direction to the respondent authorities concerned. The investigation proceedings, including summons issued under Section 131 (bracket 1 capital A close bracket) of the IT Act, being carried out by the respondent number 8, Goa, the petitioner, QUA, Goa. So next para, at the outset, Mr. Jordan Roming Thanga, learned counsel, submits that insofar as the order of penalty dated 26/3/2025 is concerned, the petitioner would not be pressing the same, since an appeal has been preferred by the petitioner under section 246 capital A of the IT Act, and the same is pending as on today. Next para. The issue to be considered in the instant case, therefore, is as to whether the order dated 25/2/2025 passed under section 127 bracket 2 of the IT Act would be sustainable without the petitioner having been given the opportunity to be heard. As alleged by the petitioner. Stop. Mr. Jordan Roming Thanga, learned counsel, by referring to section 127 of the IT Act, Hmm, 127, after that you write within bracket 2, thereafter within bracket small a of the IT Act, submits that prior to transferring the case from one assessing officer to the another assessing officer, there has to be an agreement between the principal commissioner or commissioners to whom the assessing officers are subordinate to, and further, reasonable opportunity of being heard is to be given to the assessee wherever it is possible to do so. And only after that, and after recording the reasons for doing so, an order can be passed transferring the case. Stop. He submits that from a perusal of the impugned order dated 25/2/2025, it can be seen that The order of transfer was passed on the ground that no objection was received from the petitioner. Stop referring to the communication dated 24/2/2025, bracket annexure 4. The Learned Counsel submits that a notice was issued informing the petitioner about the proposal to pass an order under Section 127 of the IT Act for transferring of the case, and for which the petitioner was given 5 days' time from the date of receipt of the notice. Stop. However, the impugn order came to be passed just the next day, purportedly on the ground that there was a modification of the notice by granting the petitioner up to 1500 hours of 25/2/2025 to give her response. So under the circumstance, the Learned Counsel submits that the impugn order of transfer, being in clear violation of the principles of natural justice as provided in the provision itself, the same should be set aside. Stop. In support of his submission, the Learned Counsel has relied upon the case of Nurul Islam Educational Trust versus Commissioner of Income Tax and others, 2017-12 SCC 805. The Learned Counsel also submits that if the contention of the respondents is to be accepted that the petitioner had sent an email agreeing to the transfer, the same is not reflected in the impugn order dated 25/2/2025. Since it rather states that no objection was called from the petitioner, but the same was not received from her till the date of passing of the order. Stop. He submits that even on this ground, the impugn order dated 25/2/2025 is not sustainable and should be set aside. Next para, Mr. S. Chetia, Learned Standing Counsel, Income Tax, on the other hand, submits that insofar as the challenge sought to be made to the order of penalty dated 26/3/2025, passed under Section 271, capital D, capital A of the Income Tax Act, the petitioner has already availed for a remedy by filing an appeal under Section 246, capital A of the IT Act, which is pending till date. And therefore, as parallel proceedings are not permissible in law, as per the established principles, the writ petition, insofar as the challenge sought to be made to the order of penalty should not be entertained and be rejected by this court. Stop. Insofar as the challenge made to the order passed under section 127 bracket 2 of the IT Act on 25/2/2025, the Learned Standing Council submits that the authority concerned acted within his power to pass the order He submits that the petitioner indeed was given an opportunity on the proposed transfer, as can be seen from the letter dated 24/2/2025. Stop. However, no, not stop, you cancel that. Which invited objection from the petitioner within a time frame. Stop. However, considering the fact that a show cause notice had earlier been issued by the Principal Commissioner Income Tax, correct? PCIT, Shillong, on 11/2/2025 for compliance of DIN letter number ITBA/COM/F/17/2024-25/1073634857 bracket 1 issued on 24/2/2025. No, the bracket 1, okay, the rest you cut. The notice issued on 24/1/2025 was amended to the effect that objection, if any, should reach the issuing authority by 1500 hours of 25/2/2025. It was also indicated that personal presence was not required and online submission of objection would be acceptable and considered. Accordingly, the email ID for giving a response to the communication was also provided. He submits that in response to the same, the petitioner write a reply email communicated that she has no objection for centralization of her PAN, PAN, bold. Under the circumstance, the order of transfer dated 25/2/2023 is in order. Full stop. He also submits that the order of transfer was passed as agreed to by the authorities concerned, and the same has clearly been reflected in the order itself, which says that the order was passed as per the proposal received from PCIT Central Guwahati, white letter dated 5/2/2025. Stop. He therefore submits that the writ petition has no merit and the same should be dismissed. Next para, I have heard the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record. As already noted herein above, the issue to be considered is as to whether the order dated 25/2/2025 passed under section 127 bracket 2 of the IT Act can be sustained. Stop. The order, as already stated, is an order by which the case has been transferred from ITO Ward 1 Silchar to DCIT Central Circle 1 at Guwahati. Stop. The impugn order also mentions that the order is passed as per the proposal received from the PCIT Central Guwahati, white letter dated 5/2/2025. And also as per the instructions received. And the satisfaction arrived that centralization of the case at DCIT Central Circle 1, Guwahati, is necessary for the purpose of coordinated investigation and to examine all the interlinking evidences gathered in the case. Stop. The impugn order further states that white letters dated 24/2/2025 and 25/2/2025, objections, if any, was called from the SSE, that is the petitioner, but there was no response till the date of the order, and therefore it was presumed that the SSE has no objection to the proposed transfer. Accordingly, the order was issued, and which came into force with immediate effect. Stop. The counter affidavit filed by the respondent numbers 2 to 10 however, shows that a reply or response was made by the petitioner via email, wherein she had written that she has no objection for centralization of her PAN. The date of the email is 25/2/2025 and the timing is 05:46 p.m. Stop. The learned counsel for the petitioner submits that as per the instructions received from his client, she is not aware about the email that was sent as projected by the respondents. And moreover, even if the mail was sent as alleged, the same would definitely have been reflected in the impugned order of transfer. The order of transfer otherwise states that no objection, no response was received from the SSE/petitioner. On this issue, we may consider the fact that the proceeding before this court is a writ proceeding wherein the disputes are decided on the basis of affidavits filed by the parties concerned. Unlike a civil court, wherein evidences are taken as per the prescribed law, to deal the matter no, cancel that. Therefore, if a dispute is raised as regards the correctness or otherwise of the email that has been sent, the same would mean that there are disputed questions of fact, and for which the jurisdiction of a writ court would be ousted on that ground. Stop. However, this court is of the considered view that one need not go to that extent, for the simple reason that the impugn order had been passed on 25th of February 2025. And pursuant to which an order of penalty had also been passed on 26/3/2025 under section 2271 capital D capital A of the IT Act. Stop. The petitioner on the other hand has approached this court by filing the instant writ petition only on 21/8/2025. Stop. In other words, if the petitioner was truly aggrieved with the impugn order dated 25/2/2025 and disagreed with the fact of having given consent to the transfer of the case, the petitioner ought to have availed of a remedy without waste of time. Stop. Insofar as the order of penalty is concerned, it is not in dispute that an appeal has been filed by the petitioner before the appellate forum. And it can be seen that insofar as penalty is concerned, the petitioner has been prompt to seek recourse to the remedy available, unlike the order passed for transfer of the case. Stop. The case of Nurul Islam Educational Trust Supra has been relied upon by the learned counsel for the petitioner, wherein the Supreme Court has held that an agreement is a must for transfer of case. Stop. In the present case, we may notice that the order has been passed as per the proposal received from the PCIT Central Guwahati. And therefore, it can be understood that there was a mutual consensus between the PCIT Shillong and the PCIT Central Guwahati for transferring the case. From one assessing officer to the other. Stop. Therefore, upon due consideration of the case projected by the petitioner, this court does not find merit in the writ petition and accordingly dismisses the same, by however leaving the costs to the respective parties.
I am obliged, Lord. My Lord, my IA is also to be closed.
Yes. The interim order passed earlier stands vacated. Then in the IA, right, in view of the order passed today in the main writ petition, the IA stands disposed of as well.
Deeply obliged.
Item numbers 8 and 9.
May it please your Lordship. Lordship, I'm appearing on behalf of my senior for the respondent number 4 and 5, the MPSC, my Lord. There has been a new development in this matter, my Lord. The petitioner number 1 has recently qualified for the Mizoram Civil Service Examination, my Lord. And if I may be allowed 1 week's time to gather further instructions in the matter, my Lord.
You're for the petition.
I'm for the petition.
Petition number 1 is qualified for the
Mizoram Civil Service Examination, my Lord.
I see.
He has secured the 4th position, my Lord.
I see. How much time should he require?
1 week's time, my Lord.
Ms. Daphne
Rashmi
Tuangi,
Yes, my Lord.
correct? Learned counsel appearing on behalf of Mr. J. Silan Unsanga, standing counsel, MPSC, presenting respondent numbers 1 and 2.
4 and 5, my Lord. 3 and 4, my Lord.
Is it so?
State is 1 and 2, man.
No, costly says 1 and 2, that's why. Respondents numbers 3 and 4 submits that there are certain developments in the matter and for which she prays for a week's time to receive instructions. Stop the said prayers not opposed to by Mr. Jordan Robintanga, learned counsel for the petitioner, as well as Mr. Samuel Vaurhita Changpe, learned additional AG appearing for respondent numbers 1 and 2. In view of above, list the matter again after a week. The registry to reflect the name of additional AG Mizoram for respondent numbers 1 and 2, and Mr. J.C. Unsanga, learned counsel for respondent numbers 3 and 7. 3 and 4. Correct? 3 and 4.
Yes, my Lord.
Hereafter. Okay.
Deeply obliged.
Hearing list, item number 1.
Mr. Malhotra, what is this matter?
This is the second appeal against
short matter, lengthy matter.
Short matter, Your Worship. Your Worship, the present appellants before Your Lordship had filed a regular first appeal, which was registered as RFA 8 of 2022, but which was dismissed by the first appellate court. Your Worship, I'll take Your Lordship to the basic facts of the case. the present appellants, initially, okay, there was one man named Biak Chunga. He was married to.
Dika, you all can go. Biak Chunga.
Yes.
Yes. What about
He was married on 3 occasions. So the present respondent is his son from the first wife.
Biak Chunga.
Yes. He was married on 3 occasions.
Okay.
The respondent is the son from his first wife.
Sole respondent.
Yes, sole respondent. Then on the 3rd occasion, Mr. Byakchunga was married to one lady called Srimati Lal Dangliani in 1993.
1993.
Yes, he was married for the 3rd time to Srimati Lal
What
Dang.
about the second? From first, you have to skip to third.
Yes, well,
What
there
about
was
the second?
Second, he was married, but they had no children.
Okay.
So in the year 1993, he was married to Srimati Lal Dangliani, and in the year 1999, they purchased a plot of land together, which is the land covered by LSC number 104003/01/70 of 2003, which is located at Electric Wing.
2003.
Yes. So they constructed an Assam type building, and both the husband and wife were living there. And the respondent, although being the son of Pubyakchunga, he never resided with them.
Who's for the other side? You are there. There's only one respondent.
One respondent.
Okay.
So the respondent, although he was the son of Byakchunga, he never resided with the deceased Byakchunga. He was living with his mother throughout.
Who was staying there? The sole respondent.
The sole respondent, he never resided with his father.
Okay.
He was residing with his mother throughout. Then Your Worship, Mr. Byakchunga had died on 21st of November 2019.
November
2019. He passed away. Then his wife requested the present appellants to reside with her, Lal Dangliani. The connection between Lal Dangliani and the present appellants are that the present appellants are the nieces of Lal Dangliani late.
Who is Lal Dangliani?
She was the 3rd wife of Byakchunga.
Okay.
Lal Dangliani.
They don't have any.
No issues.
No issues.
So after Byakchunga had died on 21/11/2019, the present appellants, at the request of Lal Dangliani, 3rd wife of Byakchunga, started residing with her. Thereafter,
who are they? Present appellants.
They are the nieces of Lal Dangliani, her sister's children. The 2 appellants are the sisters of Lal Dangliani.
Sisters?
Sorry, the nieces of Lal Dangliani. So, after his death on 21/11/2019, his wife Lal Dangliani requested the appellants to come and stay with her, so they started staying with her. In the meantime, Lal Dangliani had submitted an application for grant of heirship certificate in respect of this LSC 70 of 2003, and it was registered as heirship case number 115 of 2020. and it was allowed by order dated 3rd of February 2020. And on the basis of that heirship certificate, the disputed land covered by LSC 70 of 2003 was mutated in favor of Laldang Liani by the revenue authorities. Thereafter, Your Worship, Srimati Laldang Liani died on 3rd of August 2022. Laldang Liani had passed away on 3rd of August 2022, and before her death, she had bequeathed her property to the present appellants, her nieces, and where they continue to stay till today. Then, Your Worship, after the death of Laldang Liani, on 3/8/2022, initially the respondent sent a legal notice to the mother of the appellants.
Okay, respondent is the sole,
Son
of the, from the first wife.
From the first wife.
Okay. Notice to the mother of the niece.
Appellants.
Appellants, yes.
Yes. And in the notice, he had stated that he was the legal heir of Biak Sunga, and the mother of the appellants had illegally taken possession of the disputed land. And even his third wife, Laldang Liani, had illegally obtained heirship certificate, and he had advised them to vacate the property.
LSC remains in the name of Laldang Liani.
Laldang Liani. Then he submitted an application for probate of the will dated 22/10/2019, allegedly executed by Pubiak Sunga.
Okay.
After issuing the legal notice, he submitted an application for probate of the alleged will dated 22/10/2019, executed by Biak Sunga late. And the probate case was registered as 24 of 2022. It was allowed by order dated 23/11/2022. The trial court, while probating the will dated 22/10/2019, had not issued any notice. And so the appellants were not aware of the grant of probate of the will. Thereafter, Your Worship, the respondent had, being aggrieved by the heirship certificate, which was issued to the third wife, that is Srimati Laldang Liani, heirship certificate 115 of 2020, he had subsequently belatedly filed a review petition. The review petition was registered as heirship review case number 52 of 2022. And it is pending till date. So the present appellants, being aggrieved by the probate order dated 23/11/2022, in probate case number 52 of 2020, in probate case number 24 of 2022, they had preferred an appeal before the first appellate court, which was registered as RFA 8 of 2022.
RFA
8 of 2022. And the same was dismissed by the first appellate court by order dated 6/10/2023.
By which court?
The first appellate district court, additional district and session judge 2. And now the present is the second appeal.
Against that you've come.
Yes, and by order dated 11th of June 2024, this Honorable Court had framed the substantial questions of law.
Order dated?
11th of June 2024.
How many substantial questions of law?
3.
What are they?
Number 1, whether the decision of the first appellate court that non-issue of notice to the appellants by the trial court in probate case number 24 of 2022 did not prejudice them, despite being in possession of the disputed property, is perverse and illegal. Number 2, whether the first appellate court has the jurisdiction to decide the question of title of bequeathment of the disputed property in dispute in a probate case. Number 3, whether the decision of the first appellate court being perverse is liable to be set aside and quashed.
This has been formulated already.
Yes, 11th of June.
First appellate court has decided the question of title?
Yes, Your Honor. In the sense that, Your Honor, where the claim of the appellants that the disputed property was bequeathed in their favor by their aunt, Laldang Liani, the trial court had gone to the extent of saying that they could not prove the bequeathment, and that the respondent being the son, he had first he had a priority right.
In order of preference.
Yeah, in order of preference.
First preference goes to him.
Yes. So all those questions, whether the trial court could have decided in a probate application.
And regarding notice also, it said that there's no prejudice caused to them.
Yes.
Okay. All right, we'll come back.
Yes. Should I restate the facts, Your Worship? Is it
Not
required?
necessary.
So, Your Lordship, the trial court, the probate court, without issuing any notice to the appellants, had probated the alleged will of the deceased Biak Chunga. So, the present appellants had preferred a first appeal, which was rejected by the first appellate court, on the ground that there's no need to issue any public notice to the public, and especially in the case of the appellants, vis-a-vis their standing to the disputed property.
Mr. Malhotra, we are concerned only with the probate, isn't it?
Yes, we are concerned.
Heirship is still there?
Heirship is there. There's a review petition pending against.
Achha, that review is there.
Yes, that is.
Heirship was granted, but the review has been filed.
Yes, belatedly. So now the main thing is
you filed review, isn't it?
The opposite side, the respondent.
Oh, you got the heirship certificate.
My aunt got the heirship certificate.
Your auntie got it.
Yes.
After the death of your uncle.
Yes. And
so on that basis, the LSC was mutated
in her name. And at her request, we have been living with her. Then after she passed away, then only the respondent had started claiming the land by producing a will.
No, what thing is that the LSC is in whose name now?
My aunt's name.
Aunt's name.
Yes. After
probate is there. That probate is there. Will has been probated.
Will has been probated,
but it has not been sort of. The LSC has not been transferred.
Yes, because prior to the will being probated, my auntie had already obtained the heirship certificate, and on that basis, Revenue Department had transferred the LSC to her name. So the first appellate court had decided the appeal against us mainly on the ground that
it's okay, you can go. I'll call you.
Non-issuance of the notice to us by the trial court did not prejudice us to such an extent that our interests were deeply affected, given the remoteness of standing and claim that we have vis-a-vis the property.
Probate case was allowed on 23/11/22.
Yes. Probate case was allowed on
23/11/22.
Yes.
Then heirship was granted.
Heirship was granted in 3/2/2020 to our auntie Laldang Liani.
What is the date? Heirship?
3/2/2020.
Okay. And they have filed review.
Yes.
52 of 2022. Running 4 years, how it's still pending?
Yes.
Heirship.
Yes.
Any stay order or something like that? No.
No. Because of the pendency of this appeal, I think the matter was adjourned from time to time.
That is correct, Madam. Okay. So,
if I may take your lordship to the judgment of the first appellate court.
Before that, you take me to that probate. Where is it available?
Probate is available at page 34 of the paper book. Yes. The trial court had probated the will after examining the witnesses as well as the scribe of the will. But no notice was issued to any party.
In favor of the respondent, isn't it?
Pardon?
will has been probated in favor of the respondent.
Yes, will has been.
34.
Yes.
Then appeal, the order passed in the appeal.
Page 65.
65.
The relevant portion is from para 9, page 69. Before that is all the facts of the case. I'll read from para 9.
Yes.
I've heard both the parties at length, and at the outset it is pertinent to state that the argument concerning the pecuniary jurisdiction of this court to hear this appeal has already been addressed by this court in its order dated 19/7/2023. A reiteration herein therefore is not considered necessary, as both parties are aware of the decision taken by this court and the reasons thereof. That said, it is clear from the submissions made that the issues that stand to be determined in this appeal are as follows. Number 1, whether notice inviting objections was called for by the trial court before probating the will dated 22/10/2019, whether the trial court erred in not issuing notice to the appellants. Number 2, was the procedure established by law followed by the learned trial court in probating the will dated 22/10/2019. Number 3, whether the grounds projected in this appeal by the appellants merit the setting aside of the impugned order dated 23/11/2022 and the rehearing of the probate of the will dated 22/10/2019. Reasons and decisions. On the issue of whether or not notice inviting objections was called for by the learned trial court before probating the will dated 22/10/2019, what is noticeable on analysis of the materials available before this court and perusal of the LCR is the fact that notice was not issued to the present applicants or to the public at large. In view of the aforesaid, the first question that arises on determining this point is whether notice is required to be issued to the public at large before a will is probated. In this regard, it may be noted at the very outset that it remains tried that a will is the testimony document that comes into operation after the death of the testator, and that the peculiar nature of such a document has led to Sloman provisions in the statute for making of a will and for its proof in a court of law. This is the trial court has referred to Section 29 of the Inheritance Act regarding how a will is to be executed.
Section 29.
Yes. Who can make a will? Then, if I may take a lot.
Mr. Malhotra,
yes.
This reminds me of that case, Kaitomi and all that.
Yes.
Rendered by Justice A.B. Paul. Do you remember?
Yes, it went to the Supreme Court also.
What was the result?
The Supreme Court had, I think, upheld the judgment of the trial court. By
So
which
in that case, by the learned single judge has held that nothing is much to be done. Will means will. So it comes to operation on the death of the deceased
automatically.
person. Automatically.
Yeah. Inheritance
So
is
only
automatic.
to probate, that's only a formality.
Yes.
That's what he said.
Yes.
So that might go not in your favor in this case.
Yes. In that case, Your Worship, in this case, there are 2 points raised by us. That being interested parties, the trial court should have given us notice before probating the will. And the first appellate court, while upholding the probate of the will, has further decided that we have no right to the property. I mean, it's gone beyond its jurisdiction. The probate court as well as the first appellate court, their jurisdiction is to confirm the genuineness of the will, whether it is executed in accordance with law. But
You're saying that the question posed before the first appellate court was just to decide whether the will could have been probated or not.
Yes.
Not beyond that.
Not beyond that.
Going a step further, saying that you have no right.
Yes. That is beyond its jurisdiction. question of title cannot be decided by the probate court. That is the first appellate court.
So,
So
section 29, it says, what? Who can make a will and all that?
Yes. How to make a will, who can make a will, etc.
This is relevant?
This is not
Beside the
relevant. This is not relevant.
First issue?
This is not relevant. Para 11, page 71. That said, a will being a document by its very nature, as in the case of other documents, any document that is propounded to be a will cannot be used as evidence unless at least one attesting witness has been examined for the purpose of proving its execution. If such witness is available and is capable of giving evidence as per requirements of section 68, para 11 talks about how to prove the execution of the will. So this is also not very relevant. Just talks about how the will is to be proved in the court.
Why do you say it's not relevant?
Yeah, because in our case, the main question is whether the probate court should have issued notice to us at the time of probating the will. This is the preliminary stage where the court is saying how a will is to be made, how it is to be proved, etc. But the main question involved is whether notice should have been issued to us.
So what have you placed reliance upon for that purpose?
That you're from para 12 onwards.
Tulsiram Patel also has been discussed.
Yeah, that is for issue right of notice. Para 12 onwards is
yes.
What the aforesaid inform or necessarily for this case is that for purpose of proving the will that was probated by the impugned order dated 23/11/2022, it was not necessary for the learned trial court to issue notice inviting objections from the public at large. In other words, given the nature of will as discussed above, the principle of audi alteram partem would not be violated vis-a-vis the public at large, so long as the trial court has taken care that it has called for proof of the will as per requirement of the Evidence Act, and on it being satisfied that the construction of will of a miso as prescribed by the Inheritance of Property Act 2014 was scrupulously followed. Having made this determination, moving on to the question of whether the trial court erred in not issuing notice to the appellants and therefore not giving them an opportunity to contest the probate of the will, what is important is first to consider the standing of the appellants vis-a-vis the deceased Biak Chunga so as to merit issuing of notice to them particularly. In this regard, Mr. Joseph Lal Fakoma had submitted that the appellants are daughters of the late Biak Chunga's late wife, Laldang Liani's sister. It was also submitted that the appellant number 1 resided with Laldang Liani late at the suit property upon Laldang Liani's request after the death of Biak Chunga. It is not clarified in the pleading as to when exactly appellant number 2 started residing at the suit property, but the submission in their respect is that after Laldang Liani late obtained heirship certificate with respect to the suit property by order dated 3/2/2022, she had requested and bequeathed to the appellants whatever belonged to her, including the suit property. And it is because of the bequeathing that the appellants have remained in the suit property till date. Para 13. The standing that the appellants allege that they have apropos the suit property that they consider merits the issuing of notice to them before the learned trial court probated the will dated 22/10/2019 is thus centered on the bequeathing of all of her properties, including the suit property to them by late Laldang Liani. Given that this is the claim the appellants have made, the query then is, was the claim transfer or passing of the suit property to the appellants by late Laldang Liani affected by following the necessary requirements of law? The simple answer to that is both the pleading and oral submissions made before this court by the appellants is completely devoid of any such undertaking having been taken either by them or Laldang Liani late during her lifetime, such that the late Laldang Liani's desire to bequeath to the appellants all of her properties, including the sued property, was affected in accordance with the requirements of law. Indeed, whether or not heirship certificate had been obtained by late Laldang Liani in her favor, with the respect to the sued property, is neither here nor there, because the fact of the matter remains that the transfer of sued property in favor of the appellants, as alleged, has not been affected as per law. So this finding of the first appellate court is beyond its jurisdiction. The jurisdiction of the court in a probate application, even the trial court or the first appellate court, is to find out whether the will has been executed in accordance with law, whether it is genuine, are there any suspicious circumstances, whether it can be probated. It cannot go into any other question. Here, the trial court, at the first appellate court, has gone beyond its jurisdiction and has come to a specific finding. Indeed, whether or not heirship certificate had been obtained by late Laldang Liani in her favor, with respect to the sued property, is neither here nor there, because the fact of the matter remains that transfer of the sued property in favor of the appellants, as alleged, has not been affected as per law. This is a finding by the trial court which is beyond its jurisdiction. No issue was framed, no evidence was taken in this regard. Paragraph 14. At this juncture, the contention of the appellants pertaining to the existence of another will of late Biak Chunga, that is dated 17/2/2000, may be addressed. In this regard, the projection made in that the late Biak Chunga had executed a will dated 17/10/2000, which was found in the files, that the deceased had maintained, according to which the late Biak Chunga had willed his landed property at Bethlehem Wing to his son, the respondent, while the sued property was willed by him to late Laldang Liani. With respect to the validity and effect of the will dated 17/10/2000, allegedly executed by late Biak Chunga, the main concern of this court is that the said will, being not a duly probated will, as per requirements of applicable law, it has no legal standing apropos the sued property. As such, any claim made by anyone using it as a base and through its named legatee, the late Laldang Liani, re the sued property, cannot be considered a valid claim. Thus, in view of the fact that the transfer that the appellants allege was effected in their favor, being not realized in accordance with requirements of law, the standing appellants claim they have that warrants the issue of notice to them on the ground that they have been chosen by late Laldang Liani to be inheritors of the property is lacking in merit. In this paragraph, the trial court, the first appellate court, has addressed the contention of the appellants that there was a second will, which is dated 17/10/2000, executed by the deceased Biak Chunga. But that second will was not probated. So in that regard, the finding of the trial court is that they cannot rely on the second will is very clear, which we have not disputed. But the fact remains that after the death of Biak Chunga, late Laldang Liani, his third wife, had applied for heirship. She was issued the heirship, and on that basis, the land was transferred to her name by the revenue authorities. And this situation was in the knowledge of the respondent by giving us a legal notice. But in spite of that, we were not made parties to the probate application. In Union of India versus Tulsi Ram Patel, the Honorable Supreme Court of India had emphasized the importance of right to be heard and laid down the law that the audio alterum partem rule in its fullest amplitude means that a person against whom an order to his prejudice may be passed should be informed of the allegations and the charges against him, be given an opportunity of submitting his explanation thereto, have the right to know the evidence, both oral or documentary, by which the matter is proposed to be decided against him. Now, on the question of whether the appellants would fall under the category of persons who will stand prejudiced by the impugned order as it directly affects their interests, it is important to bear in mind that the claim of the appellants, being now narrowed to those who resided with the late Laldang Liani, as per her request after the death of her husband, the prejudice that would have been caused to them is decidedly quite remote. This is because the appellants are not submitted to have made any contribution in the acquisition of the sued property, and being only those who were invited by late Laldang Liani to stay with her after her husband's death, their claim cannot be said to be stronger than the respondent, who is the direct male heir of late Byakchunga. As such, it is the considered opinion of this court that non-issuance of notice to the appellants by the learned trial court did not prejudice them to such an extent that their interests were deeply and directly affected, given the remoteness of the standing and claim they have vis-a-vis the sued property. Even if this court was to assume that late Byakchunga had no will at all and the impugned probate order did not exist, under Chapter 7 of the Inheritance of Property Act 2014, the late Laldang Liani becomes head of the family in terms of Clause 31(1) of the Act, only after no objection is obtained from children who have become major. Now the question that may arise here is whether the late Laldang Liani would have needed to obtain such no objection certificate from the respondent, given that he is the son of late Byakchunga from his first marriage before she becomes the head of the family. The answer simply is that the 2014 Act makes no differentiation between a son born from a previous marriage and a son born from a marriage subsisting at the time of the death. The only differentiation made is between legitimate and illegitimate children and children who are indang. The respondent, therefore, being the legitimate son of late Byakchunga, irrespective of the fact that he was not born from the wedlock between Byakchunga and Laldang Liani, in order for the late Laldang Liani to have become head of the family, a no objection from the respondent would arguably be required. That said, even if the circumstance had been that late Byakchunga died intestate, the respondent would not only hold the primary position in order of preference, but decidedly also have the essential pedigree to legitimately make a claim on the suit property to the exclusion of the appellants. In this regard, Your Worship, the First Appellate Court had no way considered the position of a son who has already separated from his father by way of indang. In our present case, the respondent had never lived with his father at the present and his third wife. He had continuously stayed with his mother after they had separated. So the question of indang also was not referred to. And anyway, again, the First Appellate Court has again gone beyond its jurisdiction in going to all these matters. The work of the trial court as the First Appellate Court was just to probate the will, whether it is executed in accordance with law, whether it can be probated. But the First Appellate Court has diverted from the main issue and gone into what is the right of the appellants to inherit the instant property, whether the late wife could be called head of the family without no objection from the son. These are things which the First Appellate Court had no jurisdiction to consider and decide upon. It was besides the case. Para 17. On the issue of the procedure established by law, not followed by the trial court before probating the will dated 22/10/2019, the record shows that the trial court examined both the attesting witnesses, the executor of the will, as well as the applicant and another witness on oath. Further, as confirmed by the Honorable High Court in Janet Laldin Liani versus Reverend Thang Loya, RSA 5 of 2013, of the authority that contents of documents have to be proved as documents cannot prove themselves. All documents relied upon by the respondent were proved to the satisfaction of the trial court. I'll skip this. I'll take your lordship to para 18. The learned trial court, having examined the witnesses and the documents brought on record, it is clear from the record that it was not believed that the execution of the will was surrounded by suspicious circumstances. Accordingly, on its conscience being satisfied that there were no legitimate suspicions that militated against probating the will, the learned trial court accepted the will dated 22/10/2019 as the last will of the testator Byakchunga. Further excluding the issue of notice, the appellants have not specifically challenged the legality of any of the procedures undertaken by the learned trial court. Moreover, after intent examination of the record and the evidence along with the will, there is nothing that pricks the conscience of this court with respect to the manner in which the will was executed or the consciousness the testator had of what was taking place, as well as the content of what was being executed by him or the attestation will by the witnesses. This being the case, and for reasons herein aforesaid, this court is further of the considered opinion that there is nothing brought on record by the appellants that inspires this court to agree with the contention that the procedure established by law was not followed by the trial court in probating the will dated 22/10/2019. The reckoning made by this court in the foregoing paras have clearly detailed how the appellants have been unable to substantiate the standing they allege they have on legitimate grounds. In view thereof, with respect to the issue of whether grounds projected in this appeal by the appellants merit the setting aside of the impugned order dated 23/11/2022 and the rehearing of the probate of the will dated 22/10/2019, without the need for assuming any further in-depth discussion, this court concludes that grounds projected in this appeal do not merit setting aside of the impugned order dated 23/11/2022. It is also pertinent to mention here that although fabrication was alleged by the appellants, nothing was brought on record by the appellant by which their claim of fabrication was substantiated in a material particular. Further, the witness examined, the executor of the will, as well as the legatee, are all clear on the properties of late Biak Chunga that were being willed off by him by will dated 22/10/2019. And given that the approach is to give effect to a will, once it is found to have been executed in the sound state of mind by the testator while exercising his own free will, in the presence of witnesses already stated above, mere allegation of vagueness that does not usher in profound confusion and impossibility of execution will not invalidate the will. Having discussed and considered this appeal thoroughly and for the reasons aforesaid, the court finds no ground to interfere with the order dated 23/11/2022 passed by the Learned Court of Civil Judge Senior Division 3 in probate case 24/2022, as the Learned Trial Court did not err in probating the will of late Biak Chunga. So, we have challenged the decision of the first appellate court basically on the grounds that it was necessary to have issued notice to us, because the facts reveal after the death of Biak Chunga, his property was inherited by his wife by obtaining a heirship certificate, and even the property was also transferred in her favor by the revenue authorities. Thereafter, she had invited the appellants to live with her, and before that, the case of the appellants was that she had bequeathed the property to them. And only after her death, the present respondent had started interfering with the property. Although her husband died in 2019, will was also executed in 2019. During the period Laldang Liani was alive, the respondent never once approached the court for probating the will. He approached the court only after the death of Laldang Liani. During her lifetime, he never once whispered that, no, I have a will in my favor. This property is to be inherited by me. No such claim was made by him. And once the heirship certificate was issued in favor of the auntie, and the land was transferred in her name. So we being her nieces fall into the line of inheritance. In fact, she had asked us to live with her. We had been looking after her till her death. So now this decision of the trial court that no notice was required to be issued to us is against the settled principles of law. Now, in this regard, I'd like to rely on the Supreme Court judgment 2008-10 SCC 489. It's a very short order, George. It starts from 489. I'll read from paragraph 3. It's a very short judgment. This appeal is directed against judgment and order dated 31/7/2006, passed by the Division Bench of the High Court of Madras in OSA number 219 of 2006, by which the order of grant of revocation of probate passed by the learned single judge of original site of High Court in application number so-and-so was confirmed. We have heard Mr. Thiagarajan, learned counsel appearing on behalf of the appellant, and Ms. R. Rajini, learned counsel appearing on behalf of the respondents. We have also examined the judgment under appeal as well as the materials on record. The only question that was agitated before us by Mr. Tyagarajan, learned counsel appearing for the appellant, challenging the judgment of the High Court, revoking the probate granted in respect of the will executed by the testator, was that the respondents having no caveatable interest in the estate of the deceased, the application for revocation filed by them could not be allowed. We are unable to accept these submissions made by Mr. Tyagarajan, learned counsel appearing on behalf of the appellant, only for the simple reason that admittedly the respondents were grandchildren of the testator and they have claimed the estate of the deceased on the basis of a settlement deed executed by the testator himself, which admittedly was revoked by the testator. That being the position, we must hold that the respondents had caveatable interest in the estate of the testator and therefore they are entitled to be served before final order is passed. This is very important, Your Worship. It is well settled that if a person who has even a slightest interest in the estate of the testator is entitled to file caveat and contest the grant of probate of the will of the testator. It is well settled that if a person who has even a slightest interest in the estate of the testator is entitled to file caveat and contest the grant of probate of the will of the testator. For the reasons aforesaid, we do not find any ground to interfere with the impugned order of the High Court. Mr. Tyagarajan, learned counsel appearing for the appellant, submits on instruction that the present respondents shall be made parties in the proceeding for grant of probate within a fortnight from this date. So, Your Worship, the Supreme Court has held that it is well said that if a person who has even a slight interest, in the estate of the testator is entitled to file caveat and contest the grant of probate of the will of the testator. So in our case, Your Worship, the property in dispute, it was purchased by Biak Chunga and the auntie of the present appellants in 93. Mr. Biak Chunga passed away in 2019. After his death, his wife, Laldang Liani, the auntie of the appellants, obtained heirship certificate and the Revenue Department had transferred the property in her name. Then, during the lifetime of Laldang Liani, the respondent never made any claim that he had a will in his favor. After his death, he comes out with the will and claims probate. Probate was allowed without notice to us. And we approached the first appellate court saying that the probate trial court should have issued notice to us. But the first appellate court held that, keeping in view the standing of the appellants vis-a-vis the property, no prejudice has been caused to them by non-issuance of notice to them. And apart from that, the trial court had gone further and decided that we do not have any right to the property. The claim of the respondent has a higher preference. So those are beyond the jurisdiction of the trial court. With that regard, Your Worship, there's a decision of this Honorable Court, Division Bench, 2001, 3 GLT 436. 2001, Volume 3 GLT 436.
Which paragraph?
Para 8 and 10.
Sorry?
8 and 10. I'll read para 8, page 439. It will be seen from the above that what is to be stated in the petition for probate is that the will was duly executed and the amount of assets which are likely to come to the petitioner hand. In other words, nothing is to be proved as to whether the testator owned the property sought to be bequeathed or any part thereof had been dealt with after making of the will and before the death. That is the job of the civil court. Para 9 talks about the Supreme Court judgment. Para 10, in view of the settled law by the apex court for giving answer to the question posed in the opening paragraph of the judgment, it need not detain us any further. The answer is that a probate court can only go into the genuineness and due execution of the will and nothing beyond that. It has no power to decide any question of title or the existence of the property itself or to the extent of property sought to be bequeathed. In other words, it cannot go into the question as to whether the will stood wholly or partially revoked. In this case, the question involved was whether the will was revoked. So, Your Worship, it is very clear that the probate court can only go into genuineness and due execution of the will. Nothing beyond that. No question of title can be decided by the probate court. In our case, the probate court has gone beyond its jurisdiction by deciding what is our right, whether we have any right to the property, and what is the right of the respondent, as per the Inheritance of Property Act. So the 2 points, Your Worship. Number one, we have ample interest in the property which the trial court should have considered and given notice to us. We are in possession of the property, Your Worship, till date. The second point is that the probate court had gone beyond its jurisdiction, the first appellate court, by deciding merits of our claim and whether we can claim title to the property. The first appellate court had even gone to the extent that if Biak Tsunga had died intestate without executing a will, then the claim of the respondent would have prevalence over the claim of his late wife and the appellants. My humble prayer, Your Worship, is that both the trial court and the first appellate court orders may kindly be set aside and the matter can be remanded to the trial court for issuing notice to the present appellants so that we can contest the probate application. If I may take a lordship to page 9 of the paper book. This is a notice issued by the counsel for the respondent to Pilalrin Sangi, who is the mother of the appellants. If I may read this, Subject legal notice, reference LSC number 70 of 2003, located at Electric Wing Aizawl and the building standing within its covered area. Madam, under instruction and authorization of my client, Pusilal Remliana, son of Biak Sungalate, resident of Bethlehem Wing Aizawl, I hereby give you notice as under. My client is the natural and legal heir of his late father Biak Sunga, and whereas you illegally and by unfair means take possession of landed property covered by LSC number 70 of 2003, located at Electric Wing Aizawl, and the building standing on it, and whereas Pilaldang Liani late illegally and secretly obtained heirship certificate, in that respect, my client has initiated legal proceeding to exercise his right in respect of the said landed property and the building standing on it. Therefore, lest you waste time and money, you are advised to stop your ongoing development, repair, construction, modification within the said LSC, and to vacate the said landed property and surrender the said LSC to my client immediately. Here, in the legal notice, it is clearly stated, whereas Pilaldang Liani illegally and secretly obtained heirship certificate. So, the respondent was well aware that Laldang Liani late had already obtained a heirship certificate in our favor. And this the Your Lordship will see. Your Lordship will see at page 104. Page 104, Your Lordship. This was the probate application filed by the respondent. And at page 109, the affidavit has been signed on 31st day of August 2022.
So what is...
So, Your Worship, what I'm trying to point out here, page 9 is the legal notice which was issued. Legal notice is dated 15th of August 2022. The probate application was filed thereafter. Affidavit is signed on 31st of August at page 109. Page 110, the trial court had issued notice on the probate application, had entertained the probate application on 5th of September 2022. Page 110. So, the respondent was well aware that Laldang Liani had already obtained the heirship certificate and we are in possession of the disputed property. In spite of that, in the probate application, we were not made parties. Before filing the probate application, he issued a notice to us in our mother's name. And in that notice, he has clearly stated that Laldang Liani had obtained the legal heirship illegally. But in spite of that, while filing the probate case, we were not made parties. It is not that he was not aware that heirship certificate was issued to Laldang Liani, so he did not know that the land was transferred in her name. So no notice was required. But all the facts were before him. In the order dated 11/6/2024, 3 substantial questions of law have been formulated. Number 1, whether the decision of the first appellate court that non-issuance of notice to the appellants by the trial court in probate case number 24/2022 did not prejudice them despite being in possession of the disputed property is perverse and illegal. I think this substantial question of law is answered by the normal apex court, which I've referred to, 2008 volume 10 SCC 489, end of para 5. In para 5, the finding of the apex court that it is well said that if a person who has even a slightest interest in the estate of the testator is entitled to file caveat and contest the grant of probate of the will of the testator. In our case also, Your Worship, the fact have been, it is undisputed facts that the property in dispute was inherited by the third wife, our auntie Laldang Liani. Heirship certificate was issued in her favor. She got the property transferred in her name. And during her lifetime, the respondent never produced the will. Only after her death, he produced the will. So it is very clear that we have interest in the property. And we have a right to be given a chance to contest the probate of the will. It is not that we are in possession of the property illegally. The second substantial question of law, Your Worship, whether the first appellate court has the jurisdiction to decide the question of title of bequeathment of the property, a disputed property in dispute in a probate case. The judgment, the Honorable Division Bench of our High Court has settled the matter. It is clear. The probate court can only go into the genuineness and the due execution of the will and nothing beyond that. It has no power to decide any question of title or the existence of the property itself. Here, the first appellate court, Your Worship, has decided that the bequeathment in our favor was illegal, plus even if there was no will, the stand of the respondent has to be given preference as per the Inheritance Act. I mean, so many things have been decided by the first appellate court, which are all beyond its jurisdiction. So even the question number 3, whether the decision of the first appellate court is being perverse is liable to be set aside and quashed. So it is very clear that the decision of the first appellate court is perverse. It's gone beyond its jurisdiction.
Get this book, 1993, Volume 2, SCC 507. I repeat, 1993, Volume 2, SCC 507. That's all, Mr. Malhotra?
Yes, that's it, Your Honor. If I may be given a chance to give a short reply if required.
See, I don't know whether we can finish it up today because I have to rise by 3:15.
I understand.
If you don't complete, I think we'll continue tomorrow. Let's. Yes. What is your good name?
Raymond Lalbiaksama.
Raymond?
Yes, Lalbiaksama.
Lalbiaksanga.
Biakzama.
Biaktanzava. Lalbiakzava, okay. Yes.
My Lord, first of all, what I want to say is regarding the first issue, whether the decision of the first appellate court that non-issuance of notice to the appellants by the trial court in probate case number 24 of 2022 did not prejudice them, despite being in possession of the disputed property is perverse and illegal. The only ground they claim possession of the property is the heirship certificate, which was obtained by their auntie, Laldang Liene. Laldang Liene was my mother-in-law. In order to obtain the heirship certificate for her, there are two.
She was your stepmother.
Yes. There are two important points. First thing is Section 31 of the Major Marriage, Divorce and Inheritance of Property Act. In the absence of a will, the following provisions shall apply. So, in the present case, there is a will. So, this provision cannot apply.
What is that provision?
Section 31 of the Major Marriage, Divorce and Inheritance of Property Act.
Let's have a look at that. Section 31.
Section 31. This is an inheritance of father's property. So, in the present case, there is a will duly executed by my father. That is why heirship certificate obtained in this case.
The will itself is not a document which is ready to be executed straight away, isn't it?
Yes.
It has to be probated.
Probated, that yes.
Only after it's probated, then can it be put into service. So now to probate the will, what do you say? Should notice not be issued to the other side or whoever is interested?
Yes, my daughter.
Or even in heirship case also, they normally issue notice.
The appellants came into my father's property only after the death of my father, which means there was already a speaking document. Will was already operative at that moment. That is why There was no need of serving notices to them.
Your father expired in the year 2019.
2019.
So why didn't you straight away claim your rights to that property?
My lord, for the purpose.
The will is dated. What is the date of the will?
22nd October 2019.
Huh?
22nd October.
Date of the will?
Yes.
From where are you saying that?
This is a copy of a will. English translation is there in paper book, page number 13.
13, 1-3.
Yes.
When did he die? Biak Chunga.
Biak Chunga died
22nd,
21/11/2019. Just within 1 month of executing the will.
Oh, this is October, okay. I thought the will was made after he died.
No, just within 1 month. Just within 1 month.
It's in October, 1 month, okay. Then it's okay.
So the people, to call a spade, they are strangers who came into my father's property and claim for heirship, inheritance over my father's property. They are not my relatives. They are not relatives of my father. They are not beneficiaries of the will. They are not mentioned anywhere in the will. And they had no contribution for acquisition of the property in issue. And they just came into my father's property after his death, when there was already effective document. That is why, even if notice was served to them, they have no legal ground to contest my father's will, which was executed in my favor. And regarding the property, which is already decided in the issue number 2, with your permission, may I read the English translation of will?
Yes.
I am Biak Tsuma, the father of Lalrem Liana. I am residing at Electric Veng, and now I have reached an old age. I do not have much time to live with you all. In the event of my death, the land and building owned by me shall be inherited by my one and only son. However, his mother shall reside in the said land and building as long as she is alive. And in the event of her death, my son shall inherit the same. Since I am not in a condition to write anymore, I instructed my granddaughter Tamari to write this will on my behalf. This is the reason probate of the will was a little bit delayed, and it was done after the death of Laldang Liani, his wife. That was already contained in the will. Following the contents of the will, probate was applied after the death of Laldang Liani, his wife. And also that the property which is in issue is the only property owned by my father. In the event of my death, the land and building owned by me shall be inherited by my one and only son. Even though LSC number and so on is not mentioned in the will, it is clear the property owned by him, land and building property owned by him, since he has got only one land and building property. That is why the trial court and the first appellate court also decided regarding the property which is in issue, which is already mentioned, indirectly mentioned in the will. And the order of the trial court and the order of the first appellate court is proper and according to law, since the will is executed as per the provision of Section 29 of the Major Marriage, Divorce and Inheritance of Property Act, which governs execution of a will by a Mizo. And the witnesses are examined, and the trial court satisfied itself and found that it was genuine and executed as per law.
Section, which section you say?
Section 29.
29.
Section 29 is reproduced in the judgment of the First Appellate Court.
Probate of the will must be made within 5 years. It is within 5 years.
Yes, within 5 years. And my lord, regarding the other will, which is mentioned by the appellant's counsel, for the purpose, I just want to read this with your permission, section 29, subsection 2. If the testator executes more than one will for the same property, the latter or last one will prevail over the other or others. So even if there was a previous will, the last one will prevail, which is the present
The
one.
latest edition will prevail.
Yes, yes.
What was the other will? It was written before the will which was probated.
The other will.
There were two wills.
Yes.
Was it the same thing or different?
Different, Your Worship. But since it was not probated, that's why I'm not submitting on that portion.
That will is in favor of the wife.
He had, according to that will, the property where the respondent is saying at present was given to him, and the disputed property was given to the wife.
Wife.
But that was not probated. Your Worship.
There are two properties.
Yes.
Only one
The
property.
present residence of the respondent also belonged to his father.
Same locality?
No.
Different?
Different locality.
The one which is in dispute now is in Electric Way.
Yes.
And the other one?
Bethlehem.
You reside in Bethlehem. Okay.
My lord, I reside in my own property, not my father's property.
I see. How did you acquire that property?
It was given to me during the lifetime of my father.
Your father gave it to you?
Yes.
Okay.
But since that second will was not probated, that is why we're not referring to it.
Yes.
My lord, my last submission is the appellants, whether by possession, adverse possession, which had taken place only after the death of my father, and also other claims they may have no legal ground, and they have no connection with my father, and they have no connection with the will left by my father. Therefore, this present appeal is liable to be set aside and dismissed.
But what do you say? They are in possession of that property. Supposing they also reside somewhere else, in some locality, and the property is somewhere else, then you say they have no business to come and ask for the property. It may sound to be, like acceptable, just for instance. But when a person resides in that place, and he said that they are nobody, why should they stay here? And we need not hear them, nothing like that. Can you say that?
They reside and claim inheritance on the strength of.
And you also know that they have, their auntie has obtained heirship certificate. You are aware about that also.
Obtain heirship certificate in violation of the relevant provision of law.
So that is under review, isn't it?
Yes.
Heirship is under review.
Yes, under review. Due to the pendency of this case, it is also kept pending.
Is it before the same court or different court?
Different court.
Different court. Yes, anything else?
That is my submission.
Any authority you want to rely upon?
I thought Your Worship already, my learned friend was already reading this effective provision, which was already, all the rulings were highlighted in the effective portion of the impugned judgment. I may also submit.
No, you want to rely upon the same ruling?
Yes.
Same judgment?
Same ruling, yes. That is.
You're giving us a tough time.
Regarding
both parties relying upon the same.
He's relying on the judgments relied upon by the first appellate court.
Okay, the first appellate court.
He's relying on the judgments relied upon by the first appellate court.
Okay.
No.
Mr. Malhotra, any reply?
No, Your Worship, I think it's quite clear.
Please call somebody. Okay. Is there any fixed matter tomorrow? Part one list. Okay. Item 1, hearing. Heard Mr. A.R. Malhotra, learned counsel for the appellants, and Mr. Raymond Lalbiakzama, learned counsel for the sole respondent. Stop. This is a second appeal filed by the appellants by invoking section 100 of the Code of Civil Procedure, bracket CPC. Against the decision of the lower first appellate court invite order dated 6/10/2023, passed in RFA number 8 of 2023.
Your Worship, we have impugned the order of the trial court also. In the prayer.
Wherein the first appeal preferred by the instant appellants had been dismissed. Stop. By filing the first appeal, the appellants had challenged the order dated 23/11/2022 passed by the Court of Senior Civil Judge, Roman 3, Aizawl, in probate case number 24 of 2022, by which the will left behind by Sri Byakchunga, father of the respondent, dated 22/10/2019, was probated in favor of the respondent. Stop. Therefore, by filing this second appeal, the appellants have challenged both the order passed by the lower appellate court as well as by the probate court. Stop. Next para. The dispute between the parties pertains to a certain property covered by LSE number 70 of 2003, located at Electric Way, Aizawl, with residential building standing thereon. Stop. The said property was owned by Mr. Byakchunga.
If I may, Ajahn, the claim of the appellants was that it was purchased by Byakchunga and his late wife. And they had purchased it together.
Okay. Which wife?
The third wife.
What did I say? Was owned by, was bought. After was he cancelled. The said property was bought, BOGH, bought by Sri Byakchunga and his third wife, Lal Dangliani. In the year 1999.
Yes.
Stop. Sri Byakchunga had 3 wives, and the instant respondent is his son, born out of his wedlock with the first wife. Stop. As for the appellants, they are the niece of Srimati Lal Dangliani, who is the third wife of Sri Byakchunga. Stop. After the death of Sri Byakchunga on 21/11/2019, Srimati Lal Dangliani requested the appellants, who are
They are the daughters of our sister.
who are the daughters of her sister, bracket nieces, to come and live with her on the said property. Stop. And so, while they were all living together in the said property, Srimati Laldang Liani expired when did she expire?
3rd of August 2022.
On 3/8/2022. But during her lifetime, she obtained a heirship certificate for the said property
Page 41, Your Worship. The heirship certificate.
through heirship certificate application number 115 of 2020. Stop. Accordingly, heirship certificate was granted to her by order dated 3/2/2020. Stop. The land settlement certificate thereafter was mutated in her name on the strength of the heirship certificate. Stop. However, she expired on 3/8/2022, bequeathing the land to the appellants. Next para. It is the case of the appellants that the sole respondent served a legal notice to their mother.
Page 9.
On 15/8/2022. Accusing her of illegally and secretly obtaining heirship certificate.
Your Worship, accusing Laldang Liani.
Okay, accusing Srimati Laldang Liani, bracket late, of illegally and secretly obtaining heirship certificate for the property in question, while asking the notice receiver to vacate this, to stop the development of the property in question and to vacate the same, and also to surrender the LSC to the respondent. So after serving the legal notice, the respondent submitted an application for probate of the will. Dated.
Your Worship, page 110 is the first order.
Huh? 100.
Page 110 is the first order in the probate application. The probate application is page 104.
Of the will dated
21/11/2019.
No, 22/10, I think. The will. Of the
Yes,
will dated
22/10/2019.
22/10/2019, said to have been left behind by
Biakso.
Sri Biak Chunga, late. Stop. Upon the filing of the application for probate of the said will on 31/8/2022, the Court of Senior Civil Judge Roman 3 registered the same as probate case number 24 of 2022 and thereafter fixed 14/10/2022 as for the appearance of the applicant, that is the present respondent. Stop. Consequently, White order dated 23/11/2022. The will was probated in favor of the respondent. Stop. Aggrieved with the same, the present appellants filed the regular first appeal before the lower appellate court, which however came to be dismissed. White order dated 6/10/2023. Stop. Aggrieved, the present second appeal has been filed. Stop. This court, White order dated
11/6/2024. 11/6/2024.
11/6/2024. Admitted the appeal on the following substantial questions of law. One, two, three, okay? Please abstract it from the page 17 of the order sheet, page 17. Serial number 1, 2, 3, that one only. I think I'll have to rise.
Yes, sir.
So you write like this. Next, separately, heard Mr. A.R. Malhotra, learned counsel for the appellants, and Mr. Mr. Raymond Lalbiak-Zama for the sole respondent. Stop. The learned counsels have made their rival submissions. Hearing concluded, judgment reserved. Not required. You just send it to me like that only. Okay?